There's two matters out of list from the roster of Madam Justice Gautam Chaudhary. In one case, I have filed an IA for ignoring defect. The other is defect free. May I pray for Friday?
What is the urgency? You wait for the court to come.
In one of the matters, the Jamshedpur Notified Area Committee has given a notice of penalty and may proceed for demolition of the office of the EPF. And the other one, my lord, is with respect to LPG dealers, where, my lord, they have been issued a circular whereby their customers are being transferred to other customers, which circular has been stayed by several of them.
These are matters to be taken up by the regular bench. We will not be able to actually decide these matters.
My lord, if it may only come on list, my lord,
No.
my lord will not take it up, but it will
No,
then it will.
for listing you go to the registry.
We have attempted our level best. Fresh filing matters
No,
are.
we have a circular which says that for defect-free cases they are to be listed on a particular date. You take that circular and go to the registrar. You have that circular, isn't it? We have that circular.
SOP.
Yes, SOP is there as to how the matter is to be listed.
This threat of disposition.
Yesterday, your Lordship had allowed two matters, urgent matters. Therefore, your Lordship had allowed.
Allowed
It is fixed before the Honorable Court number 16. My bank account has been freezed. Therefore, your Lordship had allowed.
Because for me,
Huge
there is
liability.
an threat of eviction. Because my colleague had mentioned the matter yesterday. Because it was allowed by your edition.
It is listed today.
Yes, because it is listed in serial number 2 of court number Honorable Court number 16.
And
Yours
again,
also.
Yes, ma'am. In my case, Learned SDM has deputed police force, and I had come before this honorable court earlier also, which was disposed of with a direction to take a decision on my representation. They did not take a decision on my representation, and they have deputed police force, and this threat of disposition. They are trying to evict transmission lines, and there's a residential house as well.
Time 2 बजे 2 बजे
This is out of the.
outside the list से क्या होगा?
It may be taken up to court once.
कोई क्या मतलब है ये तो?
my and Mar Jalan's case both are on the list, in the list, and your Lordship.
You are another mentioning.
Yes. I have to.
I
because-
thought that both of you
No,
are
no,
mentioning
we
together.
have to because your Lordship.
हम समझ
Wait.
ठीक है आप defect free है?
Yes,
You have informed the other side.
other side is state. Other side is state.
Go and seek consent.
Yes.
If they refuse, you write that they have refused consent. Still, it will be listed, but you go and at least they will be informed. चलिए इनका दोनों का केस जो भी है देखो 2:15 बजे आएगी. मेंशन स्लिप देना पड़ेगा फिर. मेंशन स्लिप देना पड़ेगा. And inform the other side. उनके absence में ऑर्डर नहीं कर सकते.
From daily list of final disposal item 1 case 2nd April 2009.
No. Yesterday's matter. Mr. Gupta.
Yes.
कल का मैटर सबसे पहले करें जो लास्ट
From
में एकदम
supplementary list item 7 2nd April 307 of 2016.
क्योंकि वो एकदम ही फ्रेश है आप उसको जरा आप हैं उसमें कौन है उसमें अपीलेंट कौन
Mr.
आप
Sharma.
मिला आपको फाइनल नहीं है
It's
ना
not there. My only submission. Therefore, I had said that I will not take more than 5 minutes. Your Lordship, there is one judgment. This is 2008, volume 4 SCC, page 594.
2008 volume 4
4 SCC, page 594.
594 yes.
Here, see. I'll just read para 15 and 16 of this judgment because this was why this case was there. It was a case where a pure and simple suit for injunction was filed without seeking a declaration of title. Then the matter went up to the Honorable Supreme Court. So what would be the possession that has been discussed in para 15 and 16, Your Lordship? That may, Your Lordship, may allow me to
Here
raise
is also
those.
injunction without seeking title.
No, here my case was that I have a title and I had claimed possession also.
You You just see the administration of justice.
No, my contention is absolutely different. So here the Honorable Court says how the possession has to be decided. So possession follows title. Particularly in cases where there is a vacant site, then here also it is absolutely a vacant. There is no building. Therefore, Your Lordship may allow me to place 1560.
I will just
Apart from
see-
this, I will not
just
see a single
I
line.
appreciate that. As to how the possession is to be decided, there is some guideline in case of vacant possession. I can simply say that you have referred to this judgment because once a matter is being remanded, the least we say the better is. The least we say as to how the appellate court has to
No, I
take
say
care of.
mine because my submission is that if Your Lordship is convinced, then Your Lordship may not even remand. That is my contention.
As a new
Your Lordship will only allow me to place. I am only referring to two
a
paragraphs.
question of law can beyond up to that.
I am below
A
5
question
minutes.
of law.
I am below 5 minutes. I have just started. Your Lordship may only therefore accept. Para 15. In a suit for permanent injunction to restrain the defendant from interfering with the plaintiff's possession, the plaintiff will have to establish as on the date the suit he was in lawful possession of the suit property and the defendant tried to interfere or disturb the lawful possession, where the property is a building or a building with appertinent land. Here is it. There may not be any difficulty in establishing possession. The plaintiff may prove physical or lawful possession either of himself or by him through his family members or agents or so and so. Even in respect of land without structures, as for example agricultural land, possession may be established with reference to actual use or cultivation. The question of title is in issue in such a suit. It may arise incidentally or collaterally. But what will happen if the property is a vacant site which is not physically possessed, used or enjoyed? In such a case, the principle is that possession follows title. If two persons claim to be in possession of a vacant site, one who is able to establish title thereto will be considered to be in possession as against the person who is not able to establish. So here, once I have established my title, I say that I am entitled to the appellate court's judgment has to be read in such a manner that once he has decided the title, then I am deemed to be in possession of the vacant. That is all.
Is it a
I'm not-
vacant land? Is it a vacant land?
It is a vacant land which I claim that I am doing
Is it a vacant
agriculture,
land?
but he does not claim it.
No. Otherwise is the truth. My Lord may kindly appreciate. This suit has been filed by the plaintiff only with regard to 2.1. My Lord, yesterday also I was saying, my Lord, that his suit itself is barred by limitation. And my Lord, there are judgments to that
Limitation we
effect
have
also.
already
There are judgments to that effect also. My Lord, so-
That story is over because I have
My Lord,
rejected your
My Lord
additional.
may kindly appreciate, there are the total demand for which we have come, my Lord, before the revenue court, it was with respect to 8.35 acres. And my Lord, out of that only, my Lord, 2.12 he is claiming illogity. So far as the 6 point and odd act lands, my Lord, even there is no, my Lord, challenge to that.
I cannot
Well,
because I am
your Lordship may kindly
purchase that
You see-
portion only.
You see, there are so many facts involved in this case, right from genealogy and so many things. But so far as possession is concerned, there are lot of evidence.
Yes.
I have seen the trial court judgment.
Yes.
There is lot of evidence,
Lot of evidence.
both documentary and oral.
My receipts are on record. He has not
So
even known
therefore, under such circumstances, even the possession is required to be decided. This, and there is nothing, we cannot say whether it's a vacant land or what land. Vacant land means what? Being unused, right? Vacant land has also many connotations. If somebody is actually performing agricultural operation there, it cannot be said to be a vacant land. The vacant land is not anything which is without a building, does not become a vacant land. It has its own shades, isn't it?
No, that has been defined in section para 15 itself. And agricultural land also, it is not a vacant land.
So therefore, under such circumstances, this matter has to be decided, and it is better to, because the trial court has referred to many of the oral and documentary evidences.
Now, only problem, I'll only disclose the problem, otherwise not.
Yes.
Now, immediately after this order is passed, then they may go over and they'll try to take.
No, there is no question of further evidence.
Absolutely.
There is
a
no
vacant.
question of further evidence. Whatever has to
He
be
would
decided.
decide it on the basis of evidences which have already been laid.
Yes,
That
yes. There
all.
is no
That
question
all.
of any further
I'll-
evidence. We will not allow the parties to create a new right over
That
it.
is all. Then
There is no question of it. I think that should be sufficient. Whatever is there, the court will decide it. Because it is not, we can't decide it, we cannot, I was just thinking whether it is possible to come to a finding. It is not possible. There are so many evidences have been placed on record. And the trial court has referred to those evidences and its conclusion also with regard to those evidences. So we cannot just copy paste that. It is not possible.
Absolutely no finding, either by the
No.
trial court or the other.
No conclusive finding as such. There is discussion of materials by trial court, but no conclusive finding. I will remind it to the appellate court.
Better to remand to trial
No,
court.
no. ये कहानी कितना चलते रहेगा?
Trial court का भी तो
trial court finding very clearly it has given a finding. Now we say
Appellate court को भेजेंगे. Appellate court is a court of fact and law, not to the trial court. We will not send it to the trial court. There is some indication, but nothing very clear. Evidences have been discussed. We will remit it to the appellate court. कल आधा लिखाए थे.
only a time limit.
Everything will be there. Your date of appearance will be there, and you will enter appearance by filing wakalatnama.
Yes, and
all the parties are represented.
No fresh.
All the parties are represented before this court. Is there anybody who is not represented?
So I am appealing for.
Okay. He is the sole respondent. पंकज जी कल भी आप एक लिए थे ना रिमांड वाला ऑर्डर 41 और 31 दोनों एक ही साथ करेक्शन करेंगे इसमें भी डेट फिक्स कर कल इसमें आधा डिक्टेशन हो चुका है थोड़ा ही लिखा Who has taken the dictation yesterday कल क्या है कल सेकेंड हाफ में कर रहे थे ना
Yes.
हाँ लास्ट में
Last, this was the last.
आई जस्ट आस्किंग हो सकता है पता कर लूँगा When the matter is taken up today, yesterday the matter was taken up, was adjourned at the request of the learned counsel for the respondent, primarily on the ground so that he could go through the improved judgments and inform this court about the findings recorded by the learned courts in connection with possession of
Appellate first.
first appellate court in connection with possession of the property. He has fairly submitted that so far as the learned appellate court is concerned, there is no finding with respect to the possession of the property. However, he has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2008 bracket close 4 SSC 594 and has referred to paragraph 15 and 16 thereof. To submit that, in case of vacant land, the title follows possession. As
Possession follows.
possession follows title, and has submitted that title has already been declared in favor of the respondent.
And therefore, possession also I would
And therefore,
I am deemed.
by default, the respondent will be entitled for possession. यही आपका कहना है? The learned counsel appearing on behalf of the appellant has opposed the prayer and has opposed the submission and has submitted that the respondent was claiming only part of the suit property and the nature of land is also required to be considered by considering the position. He has submitted that in view of the substantial question of law involved in this case, and on account of the admitted fact that the learned first appellate court has not returned any finding with regard to possession, and so far as the learned trial court is concerned, there are discussions of materials on record and no clear finding in so many words with regard to possession has been recorded. Therefore, the matter is required to be remitted back at least to the learned first appellate court, who would be the final court on fact and law. He has submitted that in case of possession being decided in favor of the appellant, some right would certainly crystallize in their favor. Okay? That's all.
All right.
Hmm?
All right.
I do not know. Some right will certainly crystallize in their
Right,
favor.
right, only right will be next.
And the possession will
And-
follow the title.
No, and
And
my,
possession will follow the
of
title.
course.
That's what I am saying.
That's after hearing
And,
the
and my submission would be, if his possession is found, then I would be entitled to obviously the consequential relief which I have prayed for recovery of possession.
in further
Because-
response, just a moment. In further response, the learned counsel for the respondent has submitted that in case the possession of the appellant is decided, then the respondent will be entitled for
Then-
further.
Then only will he.
Then only the respondent will be entitled for further follow-up action. That's all.
Entitled for relief of recovery of
Further
possession.
follow-up
Relief.
action.
Consequential relief. Then your lordship may.
For consequential relief / follow-up action. After hearing the learned counsel for the parties and considering the contours of the substantial question of law framed by this court is of the view that this court finds that the learned trial court has discussed the materials with regard to possession, but no clear finding in so many words has been made. This court also finds that the appellate court has not at all discussed the materials on record with regard to possession, has not at all returned any finding with regard to possession. And consequently, the substantial question of law is required to be answered in favor of the appellant. However, this court is of the view that the matter is, it would be suffice if the matter is remanded to the first appellate court for consideration of the materials on record, as there can be no doubt that the first appellate court is the final court of fact as well as law. बाकी वो order 41 rule 31 का कुछ करते हैं. All the issues are required to be decided. This court is of the view that
Your
all the
lordship said
issues.
that now
That's it.
this was only confined to possession.
Yes, yes.
The question
It is
of
only
law
confined
itself
to
was
possession.
so
Nothing
that
more. बाकी कुछ बोलने का जरूरत नहीं है. It will only be confined to possession. बाकी कोई finding
that
में
may
आएगा.
only be clarified. I will not
Okay.
say.
Okay. Considering the nature of the substantial question of law, this court is of the view that the remand to the first appellate court is a limited remand only for the decision on the point of possession. So far as the rival contentions which has been advanced on behalf of the learned counsel for the parties and the judgment relied upon, since this court is not inclined to make any observation in that connection, and it will certainly be open to the learned First Appellate Court to consider all the materials on record and the legal submissions to be advanced by the learned counsel for the parties. It is further made clear that the learned First Appellate Court would decide the case confining itself to the materials which has already been placed on record before the learned tribunal. ठीक है? एक डेट दे देंगे आप लोग के क्लियरेंस के लिए
हाँ।
कब का डेट दे देंगे खाली एक टेंटेटिव डेट बताइए the parties to appear before the learned First Appellate Court by
First week of May.
इतना जल्दी
अच्छा ठीक है.
orders
Whatever
देखिए
is
orders
convenient.
upload होने में बहुत
I'll
चेक
not
करके
say.
करना
Since your
पड़ता
lordship
है
asked me, therefore I said.
मतलब any
हाँ,
day
ठीक है.
जब भी ये ऑर्डर अपलोड होगा आपको 1 महीना का टाइम मिलेगा उसके बाद
ठीक.
ठीक है the counsel for the parties would appear before the court on a particular date हम देंगे by filing fresh वकालतनामा. Upon their appearance, the learned First Appellate Court shall make all endeavour to decide the first appeal as expeditiously as possible, as the title suit relates to the year 2007.
And no fresh notice will be given because
No fresh notice.
we have undertaken to appear.
The counsel for the parties have undertaken to appear before the learned court suo motu, and there is no question of giving any fresh notice. ठीक है? The needful will be done by the learned First Appellate Court within the period of 2 months from the date of the appearance.
That order perhaps is in view of the Supreme Court time fixation.
Shall make all
And
endeavour
as expeditiously as
and shall make all endeavour to decide the case. 2007 का सूट है.
but it's
3 months का.
Honorable Apex Court has said that the timeline cannot be because it will as per their list.
It can always be a
And expeditiously
supervisory
as possible is
jurisdiction.
sufficient.
As expeditiously as possible and preferably within a period of 3 months, only preferably, right? The parties to cooperate.
No, my learned friend, why he is opposing in timeline, I don't know.
No, I am only saying that the court's orders should be legal.
Okay, I'll tell you one thing. You
When
see,
the
there
Honorable
are,
Apex Court has said
when the parties agree, do you have any objection
no,
for discussion?
no,
Should I record that you don't have any objection
for what?
for expeditious disposal of the matter?
How can I object to it?
No, you can
I'm
give
agree.
consent also, you may not object.
As a counsel, I can never. So far
As a litigant, can you?
As a litigant, I don't know. But what are the situations?
I'm ready.
As a counsel, I am in the
No,
first position.
generality of words जो है ना, law के लिए छोड़ दीजिए.
I am always ready to argue and that too in the shortest possible.
As expeditiously as possible. देखिए सूट जब बहुत पुराने हो जाते हैं, इसके पहले कि लोग मरने लग जाएं, it is important, हाँ, है ना, ऐसे छोड़ने का नहीं. देखिए कितना कोई सीनियर सिटीजन है रिकॉर्ड पर बताइए, कोई सीनियर सिटीजन रिकॉर्ड पर है इसमें?
नहीं वो तो अकेले ही है. We both are agreeing. Mr. Sharma has fairly
मिस्टर
conceded
शर्मा
that he is
क्या करने
agreeing
वाले
for
आप
the timeline.
एज्यूम नहीं कर सकते.
नहीं टाइमलाइन I am always
एक जना तो डेड हो ही गया है. One has already expired.
what substitution हो सुप्रीम कोर्ट का गाइडलाइन के हिसाब से नहीं हो सकता है. That's all और हमें कुछ
नहीं तो शर्मा जी और हम दोनों तैयार हो रहे हैं that your lordship can with our consent fix a timeline.
कोई बात नहीं, उतना जरूरत नहीं. As expeditiously is more than sufficient. Considering आप देखिए 2017 का है, 2007 का है, कितना साल हो गया? 20 साल होने आए. पोजीशन के लिए लड़ रहे हैं.
पोजीशन ही में हम पोजीशन में है भी नहीं.
So you are happy? Let it go on for indefinite period of time. पता चल गया कौन पोजीशन में है. Adjournment is by itself a fruit of the litigation.
Your lordship
You won't say so. You are more experienced than me.
had mentioned preferably at least.
I have mentioned preferably 3 months from the date of the
Yes.
appearance. If you are aggrieved, you can just take your recourse. कि 3 महीना नहीं होना चाहिए, 3 साल, 30 साल कितना होना चाहिए.
सुप्रीम कोर्ट वाला जो जजमेंट
हम देख लेंगे.
कहा है कि आप टाइम फिक्स नहीं करें. क्योंकि वो एपेलेट कोर्ट का रोस्टर है, जैसे अगर कोई डायरेक्शन दूसरे सुप्रीम कोर्ट का
कोई डायरेक्शन नहीं दे रहे, प्रिफरेबली दे रहे, बस हो गया, पार्टीज टू कोऑपरेट, काफी है बस।
हमारा सिर्फ इतना ही कंसर्न है द कोर्ट्स ऑर्डर शुड बी एज लीगल, कोई एब्सोल्युटली
And my submission would be, because this is second appellate court and it is remanding the matter to the first appellate court, it can certainly while remanding give guideline to
देखिए
the-
हर एक केस का ना ये सब सुप्रीम कोर्ट के ये डायरेक्टिव्स जो है अलग अलग कंट्रीज में काम करते हैं। कुछ मैटर्स में तो ऑनरेबल सुप्रीम कोर्ट भी डायरेक्शन देते
हाँ
हैं, देते हैं कि नहीं देते, वो कोई उनका 142 में डायरेक्शन नहीं है, है
नहीं,
ना?
पहले इसमें जो डायरेक्शन हुआ था उसके लाइट में 6 मंथ्स में वहाँ पर सब चीज एडिक्शन में हो जाता था, तो उसके बाद भी हम लोग सुशांत कोर्ट का ऑर्डर को यहाँ चैलेंज करते, बाद में वो ऑर्डर मॉडिफाई हुआ।
इस तरह के मैटर्स को तो आपको तुरंत करवा लेना चाहिए।
हाँ, तुरंत।
ये 2016 से चल रहा है, कब से चल रहा है? 2016 से ये मैटर चल रहा है। अब तो कौन रिस्पॉन्सिबल है इसके लिए? Since you are in possession.
This case from Delhi list for final disclosure item 1, 2nd April 2009 of 2018.
Why pass over?
My son is
Who is your son?
Mr. A.K. Sani, sir.
Mr.
A.K. Sani, sir.
आपको फाइन लगा क्या है?
तो इसमें नहीं, कल वाला में। But here, Lord, the Lordship has framed a question of law. It's 27th of January 2025. But after going through the file notes, I have served the copy notes. I intend to file an IA for formulating another question of law which arises from the pleadings of the party. If your Lordship will formulate that note, I have already served the copy. It is ready for filing क्योंकि लिस्ट में था इसलिए नहीं फाइल हुआ. So if your Lordship will formulate note, there is no need for me to file. I may place that.
करिए एक बार जब आपको कोई लिबर्टी नहीं दिया है ना फॉर फ्रेमिंग फर्दर सब्सटेंशियल, बिना सुने तो नहीं करेंगे, इसलिए आपको जो करना है आप करिए। ये भी टाइम मांग रहे, आप भी टाइम मांग रहे, कितने साल का टाइम चाहिए?
नहीं हमको नोट्स
तो जॉइंट वेंचर है ना, टाइम लेना।
बट हम तो रेडी हो क्या है, उस क्वेश्चन पे भी हम रेडी हो क्या है जो हम फॉर्मुलेट कराना चाहते हैं, क्योंकि नोट्स अनलेस आई शो टू योर लॉर्डशिप कि दैट क्वेश्चन अराइजेस फ्रॉम द प्लीडिंग्स, आई कैन नॉट आस्क नोट टू फॉर्मुलेट दैट क्वेश्चन बिकॉज नोट्स हियर योर लॉर्डशिप विल फाइंड।
आपने वो पहले नहीं फ्रेम किया?
नहीं, पहले फ्रेम।
अब क्या फ्रेम करना चाहते हैं ऑन द बेसिस ऑफ प्लीडिंग?
But on the basis of pleadings, not the plaintiff says that they are claiming the lands on basis of a settlement. They have prayed for declaration of title and not injunction, no recovery of possession. Not the defendant in the written statement has specifically stated that we are in possession, and now not they have also filed an execution case, the plaintiff, in which they seek recovery of possession.
They can't, no?
They can't do.
Is there any direction for recovery of
There is no direction because there
तो
was
फिर
no
आप
prayer.
एग्जीक्यूशन में जाइए ना, यहाँ पे कैसे डिसाइड
नहीं,
होगा?
हम इसीलिए बोल रहे हैं not because that in absence of that since they were not in possession.
You see, I tell you,
Yes.
एग्जीक्यूशन में क्या हो रहा है? You better advise them not.
हाँ definitely not. I am saying that
जब रिकवरी ऑफ पोजीशन का कोई
हाँ,
डिग्री नहीं है, तो
डिग्री नहीं है,
एग्जीक्यूशन इज नॉट मेंटेनेबल फॉर
execution is not
रिकवरी
maintainable for recovery.
हो गया,
Absolutely.
बात खत्म। तो फिर
हाँ,
इसके लिए सब्सटेंशियल क्वेश्चन ऑफ लॉ,
हम इसके लिए substantial question of law इसीलिए formulate करना चाह रहे हैं क्योंकि once I am in possession, there is no prayer for recovery of possession, then their suit will be barred in terms of section 34 of the specific relief act. And I will cite judgments.
they are seeking declaration. no?
They are seeking only declaration,
Did you raise a plea that it is barred by
but so far as
specific
maintainability
relief?
of suit is concerned.
ये सब नहीं देखेंगे। आपको तो जो चाहिए था वो मिल ही गया, फिर क्या सोचना?
But वो तो prayer मांगे ही नहीं।
नहीं, इस तरह से नहीं करेंगे। आप जो ऑब्जेक्शंस आपने नहीं लिया है किसी भी स्टेज में,
But I have objected in the pleadings. I have
What objected in the
I have
pleading?
made specific statements in my written statement that we are in possession. The issue was framed so far as maintainability is concerned. The issue was very well there.
मेंटेनेबिलिटी का तो इतना कंटूर है कि कुछ कहने का नहीं।
And after the that was only on the
आप
ground.
अपना बहस करिए मेन पिटिशन में बहस करिए ऐसा नहीं
Lord, why I say this?
नहीं
वो if that
नहीं हो सकता है
but if that issue is framed
it
and
will not be framed there is already
But
a
if it
substantial और मैं बहुत सुन के substantial question
हाँ,
आपका frame करती हूँ
yes,
half an hour तो जरूर सुना होगा
Lord, आप सुने
ऐसे
हैं, your
नहीं।
lordship has heard and your lordship has seen the document also.
हाँ।
On basis of that, your
इसीलिए
lordship has
ऐसे हम
framed.
करते ही नहीं हम इतना लाइटली सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं फ्रेम करते तो इसीलिए जो बना है उस पर बहस करें
You should maybe ask to block a few cases.
ठीक है पास ओवर कर देते हैं request। कितने देर में
Few cases.
क्यों मतलब वो आ गया मिस्टर सानी के लिए आप हैं आप मिस्टर सानी के साथ हैं
But then, since I am the appellant, if I start, Lord, they may know.
ऐसा नहीं है सेकेंड अपील इस तरह से नहीं हो सकता इन लोगों को समझ भी नहीं आया आई एम नॉट डिमीनिंग यू राइट दी सेकेंड अपील का प्लीडिंग्स वगैरह थोड़ा टेक्निकल होता है अनलेस मिस्टर सानी हियर्स इट ही विल नॉट बी एबल टू गेट इट ठीक है पास ओवर वी हैव वन बैच मैटर एंड देन
From supplementary list of final disclosure item 1, first appeal 77 of 2023.
मिस्टर सानी आ गए इस ईयर
Yes.
चलिए ये जो सेकंड अपील वाला था ना इसका पार्ट डिक्टेशन मीनिंग के लिए थे इन्होंने दिया है हाँ इनको इट्स अ शॉर्ट ऑर्डर दिस विल नॉट टेक मच टाइम
The
यस
exhibit was called for by us.
एग्जिबिट आ गए
Yes.
एग्जिबिट एफ
Exhibit F. Lord, we see the question of law first and then.
हाँ थोड़ा बताइए
हाँ.
भूल गए
Yes.
नहीं हो गया
Lord, question of law is your chip notes referred 27th of January 2025 order.
यस
Yes. May I read this?
यस
Heard the counsel appearing on behalf of the appellant, it is submitted that original sale deed dated 10/147 was produced by the plaintiff before the trial court, which was marked exhibit 1 by A. But the sale deed nahi hai ye, that is registered patta by both parties. They are claiming on registered patta and the date is 3/147.
रजिस्टर्ड पट्टा इज व्हाट
Settlement patta.
सेटलमेंट दिस इज एग्जिबिट
Exhibit 1 by A. The date is 3/147.
Just a minute. One by A is registered. Okay.
Yes. This is the document on basis of which the plaintiff claims that their ancestors were granted settlement by the ex-landlord. That is 3/147, Exhibit 1 by A. This certified copy was produced before the appellate court by way of additional evidence at the appellate stage, which was marked as Exhibit F. So note, they filed 1 by A. I have filed before the appellate court, which was marked as Exhibit F. Certified copy. He submitted that in the sale deed, note this should be registered patta dated 3/147, as well as in its certified copy Exhibit F, khata number 122, and the suit khata is 121. He submits that the appellate court has failed to consider this aspect of the matter, and therefore the judgment passed by the learned appellate court is perverse. The learned counsel for the appellant has referred to substantial question of law, and therefore notes question of law 4. Whether the judgment of the learned court below is vitiated for irrelevant consideration of Exhibit F, which is certified copy of sale deed dated 10/147, from which it is evident that khata number mentioned in the sale deed is 122 and the suit khata is 121, and therefore the finding of the court in relation to Exhibit F are perverse. So your lordship has to see notes Exhibit 1 by A and its certified copy Exhibit F and the pleadings of the parties that whether since the suit property belongs to khata number 121. Now your lordship may kindly take note Exhibit 1 by A.
Paliplate.
Ah.
Paliplate.
Trade. Yes.
Yes, plaint is there.
Yes. But we have placed this plaint. First paragraph. That the plaintiff is the occupancy right of land of Khata number 121 of village Kalso, PS Badi, plot number so and so, area itna more fully described in schedule A of the plaint, which may be treated as part of the plaint. That the land of Khata number 121 of village Kalso was recorded during the judicial survey and settlement operation as Germajulwa Khar of the ex-landlady Kalavati Puri, widow of wife of Jai Ram Bharose Pandit. The Chaman Badi, son of Dayal Mistri, approached the ex-landlady for settlement of the land of Khata number 121 of village Kasur, police station so and so, for settlement of land of Khata number 121. The landlady granted registered patta deed number 8 dated 3/147 in favor of Chaman Badi with respect to land of plot number 3846, area 6.50 acres out of 61.40 acres, and put the settlee in possession over the land more fully described in Schedule A of the plain, which may be treated as part of the plain. Chaman Badi thereafter developed the land by removing shrubs and bushes from the land and converted the land into paddy fields and tar and grew crops over the land and appropriated the produce therefrom without any let or hindrance, and by remaining in continuous and uninterrupted possession acquired and perfected title over the Schedule A. Chaman Badi paid rent to the ex-landlady, and after vesting zamindari, rent was paid to the state. Chaman Badi died leaving behind his sons Mohan Rana, Ramlal Rana, Raghu Rana and Mahadev Rana, who inherited the land of their father, but they could not continue in joint possession over the land of plot number so and so, and they divided the land equally. Each got the land to the extent of his share, remained in possession of the land in question. The Ramlal Rana, son of Chaman Rana, sold his share in the land of plot number for his legal necessity in favor of plaintiff's mother by virtue of a registered sale deed. They are number so and so dated 27/10/1983, measuring an area of 1.62, 2.5 acres, bounded north so and so so. That after the death of the heir with their mother of the plaintiff, the land mentioned in above was inherited by the plaintiff, who came in possession over the land. Thus, the plaintiff have been coming in possession over this land to the extent of 3.25 acres described in Schedule A of the plaintiff. That the plaintiff remained in continuous and uninterrupted possession over the land of Schedule A, which is in
That's why the entire plaint is all about 121.
Yes, 121.
Yes.
Now,
And the area of the schedule is also deleted by. There are so many amendments. लगता है कुछ typographical mistake हुआ था उसमें 121 का error छूट गया.
but now your lordship may see, but this, your lordship may kindly make a note, Lord. This suit was filed.
And the written statement is also referring to plot number 120.
Because I am claiming 121
That's right.
on basis of a hukumnama of the year 1941, coupled with delivery of possession and rent received by the zamindar and state rent received.
Yes.
So, Lord, we have said that we are in possession of 121.
That's right.
There is no land described.
Okay, let us see the document. The
Yes,
matter
now,
will be
no,
over.
just before that, your lordship may kindly make a note. Note the suit is filed not on 19/2/2001.
Yes.
Now, your lordship may kindly take first note the exhibit E itself.
Exhibit capital E.
Yes, capital E.
What is there in exhibit E, and
Yes.
why do you want us to take?
Yes, I just want to show that before filing of the suit itself, the plaintiff was aware that in their deed there is no mention of Khata 121, it is 122 which is mentioned.
Exhibit E.
Exhibit E notes, I have put a plastic flag notes.
Yes. Yes.
Have you lordship got that?
Exhibit E. Exhibit E. Yes.
Yes. But let me just place this.
Yes.
But this is between Arjun Rana and Govind Singh. These are the parties. Now your lordship may kindly flip the page next.
They are the parties or their descendants are the parties?
No, they are party.
They are the parties.
हाँ, जो appellant है उनका ये हुआ है, लेकिन अर्जुन राणा से नंबर. नोट नेक्स्ट पेज 15/7/2000 का
Yes.
ऑर्डर यस दोनों पक्षों द्वारा प्रस्तुत कागजातों का अवलोकन किया प्रथम पक्ष अर्जुन राणा ही इज द प्लेंटिफ कागजात तंजा
You
नंबर
are the
7
plaintiff or the defendant?
एंड डिफेंडेंट तंजा नंबर 7 के साथ है केवाला नंबर 45 दिनांक 3/1/47 जो उनका है सेटलमेंट द्वारा प्रथम पक्ष के पूर्वज चमन पढ़ी भूतपूर्व जमींदार से मौजा खेसरो खाता नंबर 122 खेसरा नंबर 3846 रकबा 6140 एकड़ मध्ये 6.50 एकड़ खरीद किए हैं केवाला में खाता नंबर 121 का के जगह पर खाता नंबर 122 लिखा हुआ है जो गलत ही सेज कि जो डीड है 3147 का उसमें 122 लिखा हुआ है लेकिन वो 121 होना चाहिए जो गलत है तो दिस इज डेट इज 15/7/2000 so he was aware prior to filing of the suit that in their deed of the year 1947 the khata number is wrongly mentioned. I just wanted to show this to you. And in spite of this, being aware of this fact, in a proceeding, they have mentioned all throughout khata number 121. They have not pleaded.
They could have stated in the or sought a declaration in the suit itself that this
Exactly.
khata number has been wrongly mentioned.
Exactly.
So
Not-
it be declared that it has to be read as khata number
Exactly. Not, or they could have filed an amendment in the pleading that it was a mistake, typing mistake, and therefore it should be read as khata number 122, and the document should be referred. Now, Your Lordship may kindly take exhibit 1/A.
1
जो
by
1/A जो इनका डॉक्यूमेंट है जिसपे दे रिलाई
1 by A में तो 122 होगा ही.
नहीं 1/A में
120
किस तरीके से 121
अच्छा
जो
उसको insert
उसको घुमा करके मिलोड 2 जो है उसको 1 कैसे किया गया
litigant लोग दे.
अब उसके बाद नोट सर्टिफाइड कॉपी भी हम दिखाएंगे जो एकदम क्लियर हो जाएगा कि हाँ क्या है क्योंकि ये अपने एडमिट किए नोट इनका अपना स्टेटमेंट है अपना एडमिशन है कि हाँ उस पर गलती से 122 लिखा हुआ है हम उसमें भी नोट फ्लैग लगाए वो प्लास्टिक वाला फ्लैग
लिस्ट इसमें भी लगा.
हाँ, हाँ.
हाँ ठीक.
हम इसलिए मार्क कर दिए सो
हम देख रहे हैं ये किया हुआ है.
हाँ Lord has seen the manipulation note किस तरीके and now your lordship में side by side
122 को 121 किया.
exactly अब lord side by side exhibit F जो your lord which your lordship called उसको देखते हैं
Which is the certified copy.
which is certified copy but I will just pass on my copy क्योंकि उसमें हम highlight कर दिए कोर्ट वाला कॉपी में तो हम नहीं कर सकते इसलिए हम अपना कॉपी में कर दिए लॉर्डशिप में जस्ट कंपेयर कि ये 122 है
थाना नंबर 122.
नहीं नोट ऊपर में देखिए लॉर्डशिप इसीलिए क्योंकि वो कंफ्यूजन हमको भी लग रहा था रात को तो नोट जहाँ थाना बर ही लिखा हुआ है और नीचे में नोट जहाँ खाता है वहाँ खाता प्लॉट लिखा हुआ है खाता नंबर क्या है
ये खाता है.
हाँ और इनका भी जो एग्जिबिट 1/A है नोट जहाँ पे देखा गया कि 100 कैसे 122 को 121 किया गया है उसमें भी
इनके डॉक्यूमेंट से ही है जो आपने दिखाया.
Exactly.
एग्जिबिट डी या व्हाटएवर.
हाँ एग्जिबिट 1/A
हाँ. नहीं नॉट 1 by A. एग्जिबिट जो लोग एग्जिबिट डी या एफ
हाँ.
जो था.
एग्जिबिट E
ई.
हाँ.
उसी में ही है कि दैट दे आर
admitting this so now my lords in
It is
this
not
bag
my admission, sir. It is the order passed in Tanaja.
sir, it is
Not my case. You don't say that it admitted.
But you had filed
Yeah,
it
it may
for
be,
that
it may be
condition.
inference can be drawn, but it is not the admitted case. बार ही कह रहा है admitted.
ठीक है my lord let
Not
me
an
say
admission.
that they were aware of this fact
That can be.
yes. Let me say that they were aware of this fact that there is mention of khata number 122 but from perusal of entire plate there is no whisper that it is wrongly mentioned as 122 it should be 121 and that is the basic document on basis of which the plaintiff claim stands
क्या बोलना है मिस्टर साने? What do you have to say? He has completed. अब क्या बोलना?
Now, your lordship may kindly appreciate for a moment. So far, the original deed, which is exhibit 1 by 1, which was marked as exhibit 1 by 1, that was produced. And the date is 3rd January 1947.
Yes.
There is no dispute about it. Now, the contention which has been raised here, which was never raised before the learned court, before both the courts.
No.
I am just coming to that. The contention has been raised here that the exhibit E, which was not seen the light of the day in trial, it was marked exhibit by way of order 41 rule 27. I do not say that it resolves only for the purpose, but the opportunity which would have been explained by the plaintiff with reference to exhibit E had it been produced by them during trial. It was admitted position is that it was not produced during the trial, before the trial.
Exhibit F.
Yes. Exhibit F has been produced in the appellate order 41 rule 27. It was permitted to be allowed to be marked as an exhibit F. Now, in comparison thereto, if Lordship may kindly see for a moment, in comparison thereto, so far the original deed, which is exhibit 1 by 1, there is, according to the appellant, there is a confusion with regard to end, that is, whether it is 122 has been made interpolated as 121 or not.
No,
This-
there is no confusion.
They
There
have
is a
said
certified copy.
that is the original is not, the certified copy may be wrong, but the original cannot be. Original is original. Certified copy somebody has written, it is not a photocopy. It is written by somebody else, and that has been compared to be true. But the certified copy, that is the reason I have submitted for us. Had it been produced before the trial court, there could have been evidence in this regard, but no such opportunity in the appellate court. Now, if Lordship can see whether the original can supersede the certified copy or the certified copy can supersede the original. If in the open eyes, the defendant, after having a visual eyes over the exhibit 1 by 1, did not raise any objection. They never made out the case which has been made out for the first time in the second appeal. This should have been the objection. It is 122, it is never a 121. It was marked without any objection. And the entire contention of the plaint, coupled with the oral and documentary evidence exhibit 1 by 1, the case has been based upon and findings have been recorded by both the courts. Now, they did not raise any whisper.
What was the reason of exhibiting this certified copy?
That is,
If the original was already there,
yes, that has been marked exhibit 1.
why? What was the
But
reason?
the
What
reason
was the
not-
occasion to adduce this certified copy as evidence?
My humble submission is that it has been marked as exhibit. I cannot say so.
No,
No,
but you
but
see, just a moment.
the reason will not
If the original
the order-
document is there
Yes.
or on record,
there must now
there must be some reason of
yes,
exhibiting this.
yes. Your
What
lordship
was
is
the
correct,
reason? Yes.
but your lordship is aware of the very settled principle of law. Evidence beyond pleading is no evidence in the eyes of law, and pleading without evidence is no evidence, no pleading. So it is an evidence. Let us presume for a moment, in absence of any basic statement in the written statement. So in evidence, if I presume for a moment it necessitated,
Along with the plain, did you file the documents also?
the documents were filed not in the latter stage.
Latter stage. So
Yes.
therefore, at the stage of
No,
filing,
madam, during trial, during the examination of the witnesses, let my learned friend show a single word, but my learned friend is contending here in their mouth of the cross-examination of the PWs.
so do you want to say that if a
There are twofold of argument. First of all, the exhibit 1 by 1 was marked exhibit without any objection raised by the defendants, nor any cross-examination part of the subject to examination. No cross-examination that it is 122 which has been interpolated as 121. There is no whisper in the written statement. There is no whisper in the cross-examination. There is no denial in the case made out by the defendants. So now, if that is the first argument, the second corollary argument would be before lordship that if I presume for a moment exhibit E is a genuine one, exhibit 1 by 1 is not a genuine one. Let us presume against me. Then, Milord, your Lordship, you can see evidence, it is a piece of evidence. It is not a pleading. It cannot be constituted to be a pleading. So any evidence beyond pleading cannot be looked into, inadmissible in law. It is settled principle. So my humble submission for Lordship would be exhibit E in isolation cannot be read. Now, in this context, my learned friend already read the plaintiff in extenso. There is no dispute that he says that in fact the plaintiff and relying upon exhibit E. Exhibit E is, your Lordship, just see the nature of the document. Exhibit C, it is a tanaja. It has got no admissibility in law. It is a tanaja. Tanaja is not the final. Your Lordship, we can see section 85, 87 and 89 of the CNT Act. The tanaja is prepared for the purposes of new entry in the record of right for preparation. It's a draft, and that is called an objection raised by the parties that is decided. And it has not reached to its finality. It has got no presumption in law at all. If the finally published record of right, one can say that it is a finally published record having the presumption in law, such presumption does not attach, is not attached with the tanaja. It is a tanaja. Tanaja means the objection, and it is the view of the officer who recorded the tanaja. It cannot be said that it is my admission. There cannot be an estoppel against the statute. If the Milord, I can understand, if it reached to its finality, and it could have been a final publication of record of right, where this fact was mentioned, I could not have opened my mouth. But here I can say, Milord, with great respect, that it is a tanaja, has got no admissibility in law. So exhibit E cannot help the appellant. This is my submission. So in this context, your Lordship, may can test the, in the touchstone of these facts, the findings recorded by both the courts, the concurrent findings.
Just a moment.
Yes. Permitted to refer to only 2 paragraphs of the written statement. My learned friend helped me in reading the claim, so I will help your Lordship by reading the written statement.
Just a moment.
Written statement.
It's give me 1 minute. कौन इसको एग्जिबिट कराया है? एग्जिबिट डी ई को, एग्जिबिट ई को कौन एग्जिबिट कराया है? विच विटनेस?
डिपेंडेंट कराएं
कौन कौन? Where is the order by which the special this
that is your
additional evidence was allowed?
order sheet of authority.
Order dated
17/2/2018, 17 February 2018.
इसी कारण ही हुआ था. That was the reason for allowing them.
But the fact remains.
You see, the plaintiff has to prove his own case.
Yes. I'm
So don't. You have
I
to
am
prove
on
your
my
own
own
case.
case.
Right.
Exhibit 1 by 1.
Now this additional evidence having been allowed.
Yes.
Now the certified copy is showing
Now
that
my-
it is 122 and not 120,
According to the certified.
according to the certified.
Now, my Lord, my humble submission in this regard. But I am not repeating. That for this purpose I am in permission to refer to and read only 2 or 3 paragraphs of the written statement. The case has to be made out.
Written statement से आप केस नहीं बनाएंगे ना, आप अपना plaintiff
नहीं,
का
हम
केस
अपना केस
plaintiff
तो
बनाएंगे.
बना चुके हैं, हम उसको डिमोलिश जो कर रहे हैं.
आप नहीं बनाए हैं अपना केस,
नहीं.
क्योंकि आपका जो सर्टिफाइड कॉपी
मेरा
आया
ओरिजिनल है 121. ओरिजिनल में ही 121. हम केस बनाए 121 का. ओरिजिनल भी 121 है. That is exhibit 1 by
ओरिजिनल
1.
121 में तो ओवरराइट.
No, that is not the contention of the written statement or in the evidence or in course of argument. Not this point was taken in the learned, both the learned courts below. Now your Lordship may kindly see the paragraph, only 2 paragraphs, and I will not take much more time. Written statement, your Lordship may. Paragraph 3 of the plaint, my learned friend just now read. What has been replied, my Lordship may kindly see for me. Paragraph 3 of the plaint. In response to your Lordship may kindly see the written statement. Paragraph 9. WS.
Para 9 of the plaint.
पैरा 3 हुजूर हम अपना प्लेंट का जो लाइनेट पढ़ दें. आई एम नॉट रिपीटिंग इट.
आप अपना रिटन स्टेटमेंट का कौन सा पढ़ना चाहते हैं?
उनका रिटन स्टेटमेंट. हम तो प्लेंटिव हैं. हमारा प्लेंट तो ही पढ़ दे. और हुजूर कहेंगे तो उसको ही पढ़
हाँ
दे.
बताइए नहीं ठीक है. रिटन स्टेटमेंट में क्या
जी.
बोलते
That it is further submitted that the land of khata number 121 plot number 3846 in the last survey and settlement operation was recorded by Mujurwa Pass of ex-landlord of the village defendant number 1 Rohit Singh acquired 12.60 acres of land in plot number 3846 appertaining to khata number 121 by 14 in the year 1941 by virtue of settlement from landlord and since then are coming in continuous possession without any let or hindrance. That before vesting
ये पैरा नंबर कौन सा पढ़ेंगे?
para 9
Para 9 of the W.
WS.
ठीक है ठीक. Okay, I got it.
Para 10 before vesting the zamindari in the estate, the rent for the acquired area of 12.60 acres of plot number 3846, khata number 121 by 14 of village such and such was paid to the ex-landlord. Then para 11 previously the land of 121 plot number 3846 was partitioned Parti land. The defendants spending heavy labor and cost such and such he has been converted into a forest demarcated in the forest land. This is the case now. And now in reply to para 3, para 14. Para 3 of the plaint is totally false, misconceived, imaginary, very far from true. Reality is hence hereby denied. The law is a seller cannot have a better title what he or she has. The ex-landlord, if any, has no right to settle the land by any means to any person which has been already settled earlier to the defendants. So, my lord, the defendant also say it was settled to them in 121 khata. That is the right case. Then my settlement is illegal because it has already been settled to the defendant. So, with regard to plot number 3846 under khata number 121, which is my case. So they made out a case that this settlement is illegal. This is the case made out by them. Now,
Actually,
Your Lordship,
on the face of your document, we will take care of the certified copy.
yes,
तब तो बहुत अच्छा है. आप अपना original लेके जाइए, उसमें कुछ भी
original
add
had there been any sort of objection, that
You
could
see,
have been raised.
when that additional evidence was raised,
Yes.
right? Did you lead any evidence saying that this is incorrectly recorded in the registered document?
That has
In the
come for the
certified
first
copy?
time in this stage of argument. That Your Lordship
No,
has
not at the stage of argument.
Yes,
Exhibit
yes,
F was allowed
Yes.
only because of the reason that there is a mismatch.
Mismatch according
Who
to
will
their
explain the
contention.
mismatch?
So,
No,
in-
not according to the contention.
not the certified copy which has been produced at the stage of appellate court.
Yes.
Now, my lord, if it is their contention, therefore, in order to say so that it is mismatching with the original one,
Yes.
they have produced it. But Your Lordship may kindly see for a moment. Plot number there is no dispute. 3846. In one khata, one plot number is always there. No different plot. Different khata, different plot number. So plot number is same. 3846. Khata is 122 or 120, it is in dispute. So there is a misdescription of this. So if Your Lordship, I
In
go-
which document? In original or the certified?
that is not that was not decided by the learned appellate
So
court.
because of the reason that you never raised a plea that there is no such
There was no
plot
opportunity,
number.
no opportunity
There
to
was
amend the-
opportunity. You see, the moment
But Your
additional
Lordship, in
evidence is
absence
there.
of any pleading, Your Lordship, may kindly see, in absence of any pleading in the claim,
That's
the defendants are not supposed to reply.
that's
Let us presume for a moment. So likewise, if the defendant did not set up such case in their written statement, in their evidence laid in course of trial, then what necessitated for the plaintiff to rebut it? This is my submission. So in absence of basic statement in the defense in the written statement, there was no need. Therefore, I refer the decision. I will also substantiate my argument that evidence beyond pleading would not be looked into. And this is the plea which has been taken for the first time in the second appellate stage, that this document is not correct, original one. No such pleading in the trial.
you have seen the records.
Number
Then
one.
which judgment do you want to send?
No, that at the moment I will give you within a
When? अभी हम order दिखाएंगे. आपको क्या लगता है?
mismatch का judgment which you have there.
Mismatch का judgment का बात नहीं है, Mr. Sahni. Whenever additional evidence is led by any of the party,
Yes, yes.
right, the other party has
We-
got the opportunity to adduce further evidence.
No such order was
Order
passed.
का क्या जरूरत है इसकी?
No such order was passed.
No requirement.
It requires
No.
because not the
such
opportunity
order is.
at the appellate stage. Your Lordship, you can see order 41/27. There are two things. Not one party is A and another is B. So far A is concerned, it is for the parties. B is concerned, it is for the court. Now, Lord, Your Lordship, you can see how the learned courts have dealt with the matter. This issue was not raised even in the trial court nor in the appellate court.
That's right.
Except the marking of it, mere marking will not be suffice to look into the entire contents. Contents have not been proved by leading evidence. It is a mere marking of an document. It is a mere marking, and the contents have not been proved as required under Section 65 of the Indian Evidence Act. The contents is to be proved. And so far my document is concerned, exhibit one by one, the contents have been proved by examining witness. Here in this case exhibit F did not mere marking, only mere marking, not the contents. Therefore, my lord, it has not rightly been held by the appellate court. Your Lordship, may kindly see the trial court There was no occasion for the trial court to deal with the question. Now, Your Lordship may kindly see in the appellate court judgment, I will refer.
You see, in the order it is mentioned that the learned counsel for the respondent, Mr. So-and-so, submits that he does not want to produce any document in rebuttal. हो गया बात खत्म?
But Your Lordship may kindly see, if I accept everything, then the fact remains that mere marking of an document.
Mr. Sani, you are not understanding one thing and not appreciating maybe that it is a plaintiff who has to prove this.
Yes, I still
So
say.
therefore, if your document is in cloud,
Now,
who will clear that? You
so
forget about what the defendant has said. You
But
forget,
my
sir. Let
document
us
is
assume for a moment that it is
exhibit
ex
one
parte.
by one is my
Let us
document.
assume for a moment that the proceeding is ex parte without any written statement.
Yes, then
Let
I
us
have
assume.
to, I have to,
You have to prove your
I have to
case.
succeed or
Suppose
fail
at the
on
stage,
my evidence.
suppose at the first appellate stage, the defendant comes up with a document saying that this is the certified copy
So
of
it
the
is
document.
their case. It is their case.
No, it is not their case.
Yes, yes.
It falsifies your document.
It is their case that it falsifies. So that case is to be pleaded and proved. Your Lordship, kindly appreciate my submission. Your Lordship is correct.
Required.
I can fail or succeed on my own leg. It is a settled law. Now, since so far, my lord, the case made out by the defendants by way of defense, and that is not to be proved by me. My case I have already proved, exhibit one by one. Trial court judgment is based upon that. Now, another corollary plea which I am permitted to advance. Lordship may kindly see the trial court had no occasion to test that document, but that was not produced before the trial court. So no finding, even no issue. And then the appellate court also, Lordship may kindly see, appellate court only marking of the evidence as without any proof there of contents of that document, whether the entry is 121, who has come forward to say so. Court cannot presume, but it is to be proved and pleaded. First pleaded, then proved. In
The
absence
statements
of
made in a registered document is assumed to be correct.
then original one is there. Original is also registered document. Exhibit one by that is the vis-a-vis
So I
one.
just want to know from you that if take a hypothetical situation, right? Hypothetical situation, you get a document registered, correct? And then in the original you change. So original
No,
will
no.
be
If I stop for a
then
moment.
then the original will be taken
If-
as correct.
No. If I stop for a moment at this juncture, if the original has been changed, where is the case of the defendant? That I have changed the khata number and plot number. That is the reason I have read the written statement. There should have been amendment on their part also in the written statement. That the look here, exhibit one by one is not a genuine document, and insertion of plot number, a khata number 121 instead of 122. There must be pleading. They had also got the opportunity of amendment in the written statement. Then only the rebuttal comes. Now, Your Lordship, you can say I have made out a case in respect of khata number 121. I have proved it by way of exhibit one by one, by leading evidence in this regard, and it was admitted by both the parties. Then the trial court did not get any opportunity to discuss with regard to exhibit A, which was not before the trial court. Not before the trial court. Similarly, Your Lordship may kindly see, the contents have not been proved. Whether it is 121 in the certified copy is genuine one, that contents have not been proved. And it is plaintiff is not take the plea of defense here. He is the plaintiff. And defendant, without making any case in the written statement, merely produce exhibits F at the appellate stage that cannot be looked into. This is my submission, subject to your Lordship's kind appreciation. And so far, this description of the property, I want to rely upon the Supreme Court judgment below. That's 1962 SCR, page 753.
यहाँ तो आपके लिए कॉपी भी लाए
So only threefold argument which I may be permitted to place before Lordship. First of all, I am not repeating.
Yes.
First of all, my lord, the exhibit one by one has been proved by witness. Number one, exhibit A has been marked as an exhibit without any proof. Contents have not been proved. Number three,
Just a minute.
no witness has been examined to prove its contents. Number three, below, evidence beyond pleading. Inadmissible. Inadmissible. Number four, no issue. It was not occasioned the trial court to frame any issue in this regard. It was never raised before the trial court or appellate. So the trial court did not have the opportunity to decide this.
Appellate court also did not.
Appellate court will not be mere marking.
No, appellate court framed an issue to this
No,
effect.
appellate court will not be the mere marking.
Any point
So
of
therefore,
determination
will not
on
be
this?
If alternatively, not in the last argument, without prejudice to my previous argument, then the appellate court has to test it because it was before the appellate court. If they had raised such objection, it could have been addressed and it could have been adjudicated by the appellate court, but it has not been done. So I against me, I am arguing. At best, it requires reconsideration by the appellate court. And it should not be taken from my side, but in the law, my lord, because it has before the appellate court. But you will also just see for a moment, exhibit E has been discussed by exhibit F has been discussed by the learned appellate court in one what manner. I'll just refer to my lord para.
एक second.
Para-
Please, just.
para
Just a
11
moment.
would
Please hold it.
I have just now provided with a copy of IA.
IA?
The learned friend has provided.
But I just informed.
नहीं वो सब rejected.
Para 11 हुजूर अगर देखेंगे, para 11, page 7, inner page 7 of the appellate court judgment. Page inner page 7 नीचे लिखा हुआ है
बस सारे document.
ज़्यादा बड़ा केस नहीं,
ज़्यादा बड़ा केस नहीं है लेकिन
नहीं ज़्यादा डॉक्यूमेंट नहीं, हुजूर
technical
page 7 हुजूर देखा जाए.
of the appellate court judgment.
जी, para 11 नीचे पेज
बताइए.
जी. On the other hand, appellants, defendants have produced oral evidence such and such. Exhibit A to B1 हम उसको skip कर रहे हैं. नीचे लाइन. Exhibit A जो appellate court में produced is filed during the pendency of the appeal which is certified to be.
Page 11 बोले ना, para 11 बोले.
Para 11,
Para
page
11
7.
was page 7.
Page
Page
7,
हाँ.
page 7 हो जो para 11.
Para 11.
उसका last part, last paragraph.
हाँ.
Exhibit A is filed during the pendency of the appeal which is certified to be of Swatantra, executed by Kalavati query in favor of Chaman Bari of Khata number 122, plot number 3846, 12 acres, 60 decimal out of 61, 40 decimal. situated at village such and such. The learned counsel for the appellant submitted that the judgment and decree of the court below is bad in law in the facts and circumstances. So skip कर. आगे और use देखा जाए. 1941, 1947 submitted during the appeal, defendant filed certified copy of sale deed from which बार sale deed different in my learned friend is correct. It is a deed of
It is a registered patta.
registered patta settlement. Sale deed from which it transpires that the plaintiff's sale deed khata number is wrong. It is also submitted that the court below entered to R to decide issue number such and such. This is the submission. Now finding, Lord, you can see. Para 15, in our page 9. Para 15. The defendants also admitted in para 9 that the suit property described in suit is situated under such and such khata number 121, plot number 3846, measuring an area of 3.25. 62 एकड़ में से 12 ही क्लेम कर रहे हैं, 3.25 हम क्लेम कर रहे हैं. Village such and such. Operation was recorded Garamujurwa class of the ex-landlord of the village. Defendant number 1, Goril Singh acquired 12.60 acres of land in plot number 3846, appertaining khata number 121/14, India 1941, by virtue of settlement from ex-landlord. Since then, in continuous possession that any late or hindrance such and such. Resting Jamandari, defendant admitted that Chamanwadi died leaving behind 4 sons, Mohan Rana, Ramlal Rana, Raghu Rana and Mahadev Rana, who inherited the land. In para 15 WS, the Ramlal Rana has no right title interest over the suit. Hence, he has or had no right to execute sale deed in the name of mother of the plaintiff. This is the argument. Thus, from the above case, both parties, para 16, it is admitted by both the parties that suit property which is described in Schedule A of the plaintiff was recorded in survey settlement as Garamujurwa class of the ex-landlord Srimati Kalavati query. Further, it is also admitted by both parties that the Chamanbari had 4 sons, as admitted in para 15 of WS Mohan, Ramlal, Raghu and Mahadev, who inherited the land of their Exhibit 1/A, now the registered patta which was filed by the plaintiff. 1/A is a registered patta for the suit property described in Schedule such and such in favor of Chamanbari on 10/1/1947. Exhibit 1 is the original sale deed executed by Ramlal Rana in favor of his Bukhari Devi, mother of the plaintiff, on 27/1/1983, for which measuring 12.60 decimal out of 61.40 decimal Moja Kasara. Exhibit 2 series of the Malgujari receipts. Exhibit 3 order.
Just a moment. Exhibit 1 is dated. Just a moment.
That is your registered sale deed.
Exhibit 1/A is dated
3/147.
10/1
No,
गलत
गलत
लिखा आपने.
गलत है. 3/1/1947.
47
Yes.
for area. Description बताइए.
3.25.
नहीं.
नहीं, वो है 12.
नहीं सर, और यहाँ पे पूरा गलत लिखा होगा. एक जो केस है और जिसको डॉक्यूमेंट है 3147 जो है इससे सेटलमेंट हुआ,
हाँ.
उसमें हम लोग जो है एरिया है 6.25 6.50
6.50
डीड में ही है.
हाँ 6.50 आउट ऑफ 61.40
Exhibit 1/A is 6.50 out of
आउट ऑफ 61.40
61. ये जो 61.40 है, ठीक है, this 61.40 is in the खतियान.
Yes.
खतियान लेकिन
Dispute
खतियान
नहीं.
रिकॉर्ड में नहीं
नहीं रिकॉर्ड एग्जिबिट नहीं हुआ.
नहीं.
बाय एरिया
तो उसमें 12 एकड़ ही क्लेम कर रहे हैं, 6 एकड़ हम लोग
और
क्लेम.
ये जो 83
रोड
वाला
बना
हुआ उसके
6
नीचे
एकड़ आप क्लेम कर रहे हैं और 12 एकड़ आप कौन सा क्लेम कर रहे हैं?
वो
हम लोग क्लेम कर रहे
41
हैं खाता 121 लॉट नंबर 3846 एरिया 12.60
एक ही प्लॉट.
दिस इज व्हाट आई एम क्लेमिंग.
यस, एक ही प्लॉट का 2 आदमी क्लेमेंट है जिसका 61 एकड़.
आपका डेट कहाँ है? आपका डॉक्यूमेंट कहाँ है?
Yes.
12.60.
Yes, note that is exhibit C.
आप अपना एग्जिबिट सी लिखिए. एंजाइटी होती है उनको बुलाइए इधर इधर इधर
हम
यहाँ यहाँ आगे बैठा
हमको आगे आके सर मुझे पुलिस लेके
आप आगे आइए इधर आइए आप आगे आइए कोई बात फर्स्ट बेंच में वो जो है ना यहाँ पे बैठा He may not-
पाएंगे वहाँ से हम सोचे कि आप और आप मुझे अदरवाइज लेंगे इसलिए हम उनको उठाते
वहाँ नहीं उधर इस सीट में आपके अदर साइड भी आए हैं
नहीं नहीं
नहीं आए
और उनकी वाइफ
वो
का
तो-
तबीयत खराब है तो
अभी-
रात को हम बोले कि फाइनल
अभी
हियरिंग में
जस्ट आके
10:30
फिर
फिक्स
आपको
है
एक पॉलिथीन डरा दिए और
खाली पॉलिथीन डरा दिए।
नहीं सर्टिफाइड टू बी फ्रेंड
एंशियस हो जाते हैं ना लोग
डेफिनेटली नॉट देयर राइट्स आर इन्वॉल्वड
हम भी
Anxious
इसी
हो
रहते
जाते
तो
हैं।
शायद हम लोग भी एंग्जाइटी होते लेकिन हम
किसी
लोग
का केस रहता है तो एंशियस हो जाते हैं कोई
लेकिन
बात
हम सोचे कि मेरे बगल में क्यों इसीलिए हम उठा
एंशियस हो जाते हैं
सॉरी
इनकी एंजाइटी को समझना जरूरी है
जी ये पैरा 21 एप्लेट अच्छा सॉरी एग्जिबिट सी
बट उसका ट्रांसलेटेड कॉपी भी है नोट
बताइए
हाँ नोट वो जो एग्जिबिट एफ आया है ना
हाँ
उसी में नोट ट्रांसलेटेड
किसका ट्रांसलेट
हाँ हुक्मनामा हम इसलिए बता रहे हैं नोट कि कन्वीनियंट ऑफ नोट हम लोग भी फाइल किए थे उसके बाद हाँ बट वो फर्स्ट ही पेज में
You are also claiming from the same plot now.
आई एम क्लेमिंग सेम प्लॉट नंबर खाता नंबर 121
that plot number not total area is 62.60 acres out of which
But can
defendants are claiming
not already not subject to my senior notes argument. Not since this exhibit F was filed before the appellate court, not the appellate court did not frame any issue on this and never returned any finding about exhibit 1 by A and exhibit
About
F.
the mismatch.
Exactly.
Yes,
Because
no
there is no
issue.
finding
I have
in
a-
exhibit 1 by A में
there could be an
interpolation
occasion for additional evidence also.
yes
Oral evidence.
oral evidence
oral evidence.
to
यही हम सोच
Explain.
रहे थे।
यही जो हम भी
but इसलिए not it is better if my senior agrees
I
on this.
also
If
also
not,
submitted
this
in
needs
this
remand
He
on
is
that
right.
aspect
And that I have
because
already
there has to be a finding on that because
Okay.
once the court admits a document let us say not there is no rebuttal by the other side what your lordship has pointed out कि 4127 में allow हुआ इनको rebut नहीं so it might be a mistake of counsel arguing there at best but not the court was not
Was
He
required to
bound
respond
to
to that.
respond to that and give a finding that whether what is correct
Whether this mismatch has any bearing on it.
Yes.
exactly
There could be a situation that the identity of the property is duly proved.
yes
There could be a situation.
yes yes therefore it needs not remand To
That
this
is the reason I
extent,
also
the
submitted
exhibit
as a
1 by
last.
A and F.
हम ना परेशान हो गए हैं डिमांड करते करते. You know these we are getting certain judgments. वो एक copy paste judgment भी आया है where the appellate court's discussion of evidence is copy paste.
Yes.
In the trial court का judgment का discussion is copy paste in the appellate court, including the typographical error.
Oh, my lord,
Copy paste
एक
is
judgment
copy
हम लोग second
मतलब
में बात कर
copy paste में जो
Copy paste
गलती
होता
हो
है,
गया ना
copy
वो
paste.
भी उसमें incorrect.
नोट एक सेकंड पे में बात करते हैं ट्रायल कोर्ट का जजमेंट हिंदी में एग्जैक्टली नोट्स वर्ड बाय वर्ड उसका इंग्लिश ट्रांसलेशन जो हो सकता है दैट इज डन बाय द एंड ओनली ऑन दैट ग्राउंड नोट्स आई वाज द डिफेंडेंट सपोर्टिंग
वही इंग्लिश है तो इंग्लिश से मैं कॉपी पेस्ट
एरर हो गया मतलब उतार दिया गया है
या तो इंग्लिश टू इंग्लिश कॉपी है और जो
Error है, वो भी
गलती
copy हो
जो
गया।
टाइपोग्राफिकल एरर ग्रामेटिकल एरर जो ट्रायल कोर्ट ने किया है वो सारा का सारा वर्ड बाय वर्ड कॉपी पेस्ट
मुझे एक ही पैराग्राफ है एपेलेट कोर्ट का
उसमें हम एक सब्सटैंशियल क्वेश्चन ऑफ लॉ बनाए. देखिए बात यह है कि जैसे भी हो एपेलेट कोर्ट कंटेस्टेड पॉइंट को नहीं डिसाइड करिएगा तो कभी बोन ऑफ कंटेंशन बनेगा ही हायर कोर्ट में. अब जो भी हो डिसाइड कर देते भाई आइडेंटिटी ऑफ द प्रॉपर्टी इज नॉट
पैरा
डिस्प्यूटेड.
21 एकमात्र पैराग्राफ है जो एपेलेट कोर्ट का पैरा 21 इस मामले में वो हाफ हार्टेड है जस्ट पैरा 21 मुझे पढ़ा जाए पैरा 21 दैट इज एट पेज 12 एपेलेट कोर्ट जाए द लर्नेड काउंट पैरा 21 एपेलेट कोर्ट जाए.
Yes.
The learned counsel for the defendant appellant argued that the plaintiff's claim on the basis of playing fraud, their names mutated at the because in their vendor registered settlement in the year 1947, khata number 121 is written, but by fraud it is khata number 122, has been manipulated and the same transfers from Exhibit F certified copy of sale deed Exhibit 1 by A. That is the submission. Now, the Honorable Apex Court held in decision reported in AR 1963 Supreme Court 1870 held that the conflict between boundary, khata and plot number and boundary number shall prevail. The Honorable High Court Patna has held in 2005 Patna page 23 Ramji Rai and others and Devki such and such that mistaking plot number be treated as more discrepancy which did not identify the property sold. The case which is in hand, it is also a minor discrepancy which not affect the identity of a property sold in the year 1947 and after then it is again in the year 1983. Those sold it हमारे by the purchaser and his name is mutated since 1947. Therefore, from the discussion of documentary evidence, I find and hold that the plaintiff has better title over the suit property on the basis of documentary evidence as discussed. This is the finding.
Where is the finding that irrespective of this, the
That
identity
is
of the
not there.
property
There is
वो
no,
जो
that
है
is
ही
not
नहीं.
there. I admit, and that is the reason last submission में जो alternative argument हमने दिया कि हुजूर appellate court को भी address नहीं किया गया, ना appellate court ने return दिया finding. There is no-
Appellate court ने ये लिख दिया
उतना ही
कि
वह
the
लिखा.
case in hand is also a minor discrepancy
and better title.
and better title. But the court has
Issue-
not discussed the
Points for
materials
this-
on record.
Points for determination
पॉइंट फॉर
में ये
डिटरमिनेशन
question
फॉर्मुलेट
नहीं.
करके इशू फ्रेम करके उस पे
That is an
आंसर
admitted question. That is my last
So
answer.
the point of determination ought to have been whether
Exactly.
this discrepancy
Whether
between the original
serious
deed
dispute.
and the registered deed
Especially when
has any bearing on the identity of the property.
yes.
and what exactly is khata numbers by leading evidence, because ultimately not they need that oral evidence to support the contention of the parties,
On the other hand,
or by calling
नहीं,
notes.
तो वो बिना plain written statement amendment किए कैसे?
But definitely not अब
नहीं
तो
हो पाएगा.
क्योंकि वो जो इशू है
Now, in view of these judgments which he has referred to,
yes,
that identity of the property, the discrepancy in khata number, etc., may not be material if the identity of the property could be established on the basis of boundary, right?
that is
So, but that discussion has to be there.
definitely
That should be sufficient. बिकॉज आज के दिन में तो हम किसी को प्लेंट को रिटन स्टेटमेंट अमेंड करने के लिए तो नहीं बोल सकते हैं. हाउ डू आई से? इट इज फॉर यू टू से और नॉट टू डू और नॉट टू.
Therefore, I say कि appellate court ought to have framed the issue on this.
Yes. Whether the identity
once-
of the property is otherwise
Once the
established.
appellate court admits that order 41/27 allows that application, the appellate court ought to have framed that question of law, determination, point of determination in terms
Para
of 41.
25 of the
And then
trial
have
court
answered
judgment.
that.
Para 25 of the trial court judgment note at page 10. Trial court.
The 20 trial court में तो
वो था नहीं एग्जिबिट है,
हाँ.
लेकिन उसके बारे में बताया क्या बोले बताते हैं. Para 25. From appreciation of materials and evidences brought on record, it is found that the land was settled in favor of Chamanbari by virtue of the registered deed of Patta, while the land settled in favor of Horil Singh, independent, was by virtue of an unregistered hukumnama. Thus, unregistered hukumnama has no evidentiary value, and no any other evidence has been brought on record by the defendant to show the manner of acquisition of 12.60 acres by Horil Singh. Furthermore, the boundary of the suit property as given by the plaintiff is consistent and with the pleading and other evidences brought on record, while the boundary of the land settled in favor of defendants by virtue of unregistered hukumnama shows forest land on its three boundaries. दोनों अलग अलग जमीन है, ये जो क्लेम कर रहे हैं. Furthermore, the rent receipts of the defendants are for 12.60 acres, while as per exhibit deed, the same has been shown 12.60 bigha. As regards exhibit E, the same has no endorsement to the effect not final, which is our argument. The materials and evidences brought on record by the plaintiffs are consistent and points towards the title and possession of the suit property. Accordingly, it is held the plaintiffs have varied title and possession of the civil property, and they are further entitled for such action. So it is not the case that it has not been discussed. Now another aspect you also can see, the total area is 62.60 acre. The defendants claiming 12.60. I am claiming 6.60. So it is within 62 acres.
that means you are not claiming my land, sir.
No, as per the case made out by parties, not as a appellant, a respondent I am representing. Therefore,
If they are not claiming my lands, then why for execution?
Boundary has been, both the courts has discussed with regard to the boundary given by the plaintiff. It is consistent. So the suit plot is being identified by both the courts. Misdescription of plot number, khata number will not take away the right title interest of the plaintiff. That is my submission.
But the learned appellate court has not framed any issue.
That is at the very.
The trial court has recorded that the suit property is identified,
same what I have
etc.
claimed.
Yes, but the appellate court has not recorded any finding, particularly taken care of the document which was filed.
Exhibited. That I cannot substantiate more.
The point of determination ought to have been that on view of the additional evidence which was produced before the learned first appellate court, whether it has any bearing on the identity of the property. यही तो? On the basis of materials already available on record. इसके beyond तो कुछ नहीं. Appellate court का कहीं कोई finding है identity of the property को
तो
लेकर?
जो
बस वही है.
बस वही है जो पढ़ा.
दिखाते हैं. second appeal number 209 of 2018. सर आप जाइएगा नहीं प्लीज,
हम जाने
हाँ कोर्ट छोड़ के नहीं जाइए।
अभी
कुछ टेक्निकल चीजें
information
हैं।
है, हम लोग 1000 रुपया कॉस्ट लगा तो एक बार
नहीं बोलते टाइम लगा, 1000 लगा तो 2000 लगा, तो टाइम जहाँ
आप
मांगे
इसमें कॉस्ट लगाता नहीं।
नहीं इसमें नहीं, बट दूसरा कोर्ट
Cost
में
लग गया।
कॉस्ट लगा एक बार टाइम देने में, फिर सेकंड बार टाइम
हाँ
देने में
टाइम
फिर कॉस्ट
जितना
लगेगा।
मांगा जाए तो मिलेगा, बार बार डबल
वो मल्टीप्लाई हो जाता है। तो वही वो जूनियर को
Progressive
स्टार्ट
ratio।
किया कि नहीं 1000 लगा है, दूसरा 1000 एक
नहीं,
और
1 2
1 2 4 8 16 32 64
64
ऐसे हम लोग मल्टीप्लाई करते जाता है।
ठीक है। The litigant should pay for adjournment, इसमें क्या बोला?
गलत है, हम लॉयर के लिए तो नहीं देना चाहिए, हम तो जितना कॉस्ट लगा हम पॉकेट से लगा, मेरा दोस्त से अगर कोई टाइम नहीं,
थोड़ा थोड़ा जूनियर तक तैयार करिए।
वही तो बोले कि आर्गुमेंट कीजिए जाके, बोल सकते हैं।
सीख जाएंगे थोड़ा, हर केस में थोड़ी आपकी जरूरत है।
जी बसरते पढ़े, बसरते टाइम लगा, इन्वेस्ट करें टाइम,
इन्वेस्ट नहीं, फुल
टाइम इन्वेस्ट,
फुल टाइम।
फुल टाइम, हम तो कह रहे थोड़ा सा भी इन्वेस्ट किया।
वकालत मतलब काम के अलावा कोई काम नहीं,
जी
तब वह वकालत, नहीं तो कुछ नहीं।
सही बात, तो बहुत किए हैं।
आपका ऑफिस अभी भी 2 बजे तक चलता है क्या?
12:30
हम लोग तो यहाँ के हैं तो सब जानते हैं किसका ऑफिस कितने बजे बंद होता है। करेक्ट।
ये जी
वकील की पढ़ाई शुरू होती है 11 बजे के बाद।
उनके ग्रैंडफादर को भी हम असिस्ट किए, तो बहुत माइन्यूटली पढ़ के
बहुत।
उनका हैंडराइटिंग जो है अभी तक हमको याद है।
हम भी उनके असिस्ट।
हाँ जी,
बट हमको एक केस में जस्टिस इकबाल हो गए थे कि अपने ग्रैंडफादर का नोट देखना, पुराना फाइनल नोट्स, मतलब आई कांट इमेजिन कि 2-3 वर्ड खाली लिखा हुआ है ब्रीफ में,
और उसी
एंड जस्टिस इकबाल हमको बोले कि वो 2-3 वर्ड लिख करके सर ऐसे फाइल बंद करके he used to continuously argue for hours.
ये
Yes.
मतलब I did not have that occasion to assist him because when I came not he was
Great
too,
he was. There is no doubt.
मतलब I have seen some old files 88 or 89 the second appeal, खाली कुछ लिखा हुआ,
आप
मतलब
देखिए ना, पटना हाई कोर्ट के जो पुराने सेकंड अपील सिविल लिटिगेशन जो डिसाइड हुए हैं, आज भी सुप्रीम कोर्ट में वो साइट होते हैं, लेकिन करंट वाले नहीं साइट हो रहे हैं।
but I have developed my habit कि I prepare myself on my notebook. Every
अब
case
देखिए जो भी एकदम सेलिब्रेटेड प्रिंसिपल ऑफ लॉ है
वो पटना हाईकोर्ट से
वो पटना हाई कोर्ट से राइज किया है।
हम लोग तो सब सिंसियर क्वेश्चन 10-11 पन्ना में सब भर देते हैं, वहाँ हम देखते हैं 2 या 1 मैक्सिमम, वो 4 पन्ना का सेकंड है,
इसीलिए सब्सटेंशियल क्वेश्चन ऑफ लॉ बनाने में इतना टाइम लगा।
बहुत ही
नहीं तो क्या है कि कुछ भी बना देंगे और लिटिगेंट के अगेंस्ट में चले,
जी।
जीतने के बाद भी अगेंस्ट में चला जाएगा। चलिए, ऐसे नंबर 209 of 2018 heard the learned counsel appearing on behalf of the parties. This appeal has been filed against the judgment dated 26/3/2018 passed by learned district judge Roman G. Hazaribagh in civil appeal number 52 of 2014, by which the judgment dated 29/9/2014 and decree dated 10/11/2014 passed by senior division, learned senior division is learned senior judge Roman Court Hazaribagh entitled suit number 6 of 2001 has been confirmed. The defendants are the appellants before this court. This appeal was admitted for final hearing by the order dated 27th of January 2025 on the following substantial question of law. The records of the case reveal that title suit was filed डिक्री का टाइटल सूट का seeking a declaration they are seeking adjudication of plaintiff's right over Schedule A land and for declaration of and for confirmation of possession and for the further relief that the defendants be permanently restrained from interfering with the possession of the plaintiff with respect to the suit land. The Schedule A of the property is as under: land of Khata number 121 of village Karso, police station, Barhi, district Hazaribagh, plot number 3846. एरिया को डिलीट किया हुआ है. Bounded to North Patigadha, South Town of Bihari Singh, East सोनी सिंह क्या है? सोटी सिंह, वेस्ट चमन सिंह.
वेस्ट चमारी, CHAMARI.
वेस्ट चमारी सिंह. एरिया कैसे डिलीट कर दिया भाई?
3.25
डिग्री का कॉपी
डिग्री का कॉपी में आया 3.25
3.26 लिखा हुआ था, उसको बोल करके 3.25
अमेंडेड हुआ है.
अच्छा, amended है 3.25. ध्यान रखेंगे, ठीक है. डिग्री कहाँ है?
हाँ,
डिग्री में है.
सर्टिफाइड कॉपी कोर्ट मार्शल का
दिखाइए.
अपडेट कोर्ट का डिग्री है सर.
दोनों
ट्रायल कोर्ट का डिग्री दोनों लगा हुआ है.
ट्रायल कोर्ट का डिग्री हम तो
हाँ 3.25. 3.25
था.
ये ट्रायल ये डिग्री से लेंगे, है ना? इसमें ट्रायल कोर्ट का रिकॉर्ड में ये डिग्री है, इसको फ्लैग करो. The specific case of the plaintiff was that the land of the plaintiff was in Khata number 121, Mauza Karso, recorded as Gair Majurba Khas of erstwhile landlady Srimati Kalavati Pudri, who settled the same in favor of Chaman Barhi, son of Dayal Mistri, by virtue of registered patta deed number 8, dated 3/1/1947, in connection with plot number 3846, area 6.5 acres out of 61.40 acres of land. Chaman Bari died, leaving behind Mohan Rana, Ramlal Rana, Raghu Rana, and Mahadev Rana, who partitioned the inherited property and came in exclusive possession of their share. It was the specific case of the plaintiff that Ramlal Rana sold his share in plot number 3846 in favor of mother of the plaintiff through registered same deed number 13233, dated 27/10/1983, measuring an area of 1 acre 62.5 decimal, having boundary north Bukhari Devi, south Mahadev Rana, east Soti, and west by Chavari Singh. And upon death of Mohan Rana, along with the mother, the same was inherited by the plaintiffs, who were in possession of the land. It was a case of the plaintiff that out of 6.5 acres of land in plot number 3846, they had remained in possession of 3.25 acres, while Raghu Rana and Mahadev Rana remained in possession of the rest of the plot number 3846 and sold the same to number of purchasers. The plaintiff stated that the defendant, without having any title and possession of the suit property, claimed the same over the same and attempted to enter for their name in the survey settlement, and there was a threat of forcible dispossession of the land, and therefore the suit was filed. It was a case of the defendant that the plaintiff were never occupancy rayat of 3.25 acres of land in plot number 3846, khata number 121 of village Karsu, PS Bari, and no land as described in the schedule to the plaint ever existed. It was also asserted that the suit land was tarred TANR and some portion of the same is a part of the forest land. The defendants further asserted that their claim over area of 12.60 acres of land in plot number 3846 pertaining to khata number 121/14 of village Karso PS Bari, but they did not deny the factum that Kalvati Pugri was the landlady of the same mosque. It was the specific case of the defendants that the said landlady had already settled the suit land in favor of the defendants, and Chaman Bari never came in possession of plot number 3846. It was asserted by the plaintiff that the document in favor of Chaman Bari was forged and fabricated, and no title had accrued to him by virtue of the same document. It was also denied that sons of Chaman Bari ever came into possession of plot number 3846 upon his death. Semicolon. Ramlal Rana had no right, title and interest over the suit land to execute any sale deed in the name of the mother of the plaintiff, nor Bukhari Devi ever came in possession of the suit land on the basis of the aforesaid sale deed. Deed of sale. The defendants claimed to have been paying rent in connection with the suit property since the time of settlement of the same in their favor, and hence pleaded that the suit be dismissed. The learned trial court framed the following issues for consideration. The plaintiff had examined 4 witnesses, defendant 6 witnesses, and so far as documentary evidences are concerned, Exhibit 1 by A was the original patta.
Registered patta. Original patta of the 1947.
Original patta.
Original registered.
Original patta of the or dated
3/1/1947.
Registered.
47,
Yes.
which was a registered document, right? Original are produced किए, registered document वो produced, which was duly registered in the, which was duly registered. ये पैरा 6, 7, 8, 6 to 10 में ना सारा description इसको लेना है. The learned trial court decreed the suit and decided all the issues in favor of the plaintiff. Decided all the issues in favor of the plaintiff and recorded finding in connection with identity of the property in paragraph 25 as under. While deciding issue number 4 and 5.
Issue number 2 को हम लोग खाली mention कर दिया है. It was not pressed. By the court.
Issue number 2 was not pressed.
Not.
All the issues except issue number 2.
All the issues except issue number 4. Issue number 2. Para 25 quote कर दीजिए. So far as the learned first appellate court is concerned, the impugned judgment as well as the records as received from the learned first appellate court revealed that the certified copy of Exhibit 1 by A was produced on behalf of the defendant, who were the appellant before the first appellate court, as additional evidence. And the additional evidence was allowed and marked as Exhibit F. The order by which the additional evidence was allowed is dated
17th February 2018.
17th of February 2018.
That also perhaps not have flag marked.
Yes, that is also flagged. The perusal of the said order revealed that the additional evidence was led primarily on the ground that there was a mismatch with respect to khata number in original exhibit 1 by A as compared to its certified copy. In the certified copy, the khata number was 122 and in the original deed it was 121, and the suit was also filed by referring to khata number 121. The learned counsel for the appellant, by referring to the first appellate court's judgment, has submitted that since the certified copy revealed that the correct khata number was 122 so far as exhibit 1 by A is concerned, therefore the filing of the suit in connection with khata number 121 based on exhibit 1 by A was itself not in accordance with it.
Where there is manipulation, because that is.
He has submitted that in the original exhibit 1 by A, which was the original deed, there was certain manipulation and overwriting on the same is apparent from the document itself. The learned counsel submits that while considering this aspect of the matter, the court has not, the learned first appellate court has not taken this aspect of the matter into consideration while dismissing the appeal. He has submitted that error in the khata number goes to the root of the matter, and only on this ground the appeal was to be allowed and the decree was to be set aside. Yahi aapka
Yes.
case. He has submitted that the substantial question of law be answered in favor of the appellant and the judgment and decree of both the courts be set aside. The learned counsel appearing on behalf of the respondents has submitted that merely because there is some mismatch in connection with the khata number, alleged mismatch with respect to the khata number in the certified copy and the original deed as produced, the same by itself is not enough to set aside the judgment and decree of both the courts.
Especially when the plaintiff has already proved the bound along with the boundary.
Okay, the learned counsel has also submitted that the plaintiff had already proved the identity of the property by referring to the boundary and other evidences placed on record, and as the document was itself a registered document and the original was produced by the plaintiff,
There is no plea has been taken by the defendant in the
and no plea was taken by the defendant in the written statement regarding
evidence was made.
any mismatch in the khata number, nor the written statement was ever amended even at the first appellate stage, and therefore the impugned judgment does not call for any interference. However, during the course of argument, the learned counsel for the respondent has fairly submitted that the impact of the mismatch with respect to the certified copy and the original deed produced by the defendant and the plaintiff respectively. Defendant at the first appellate stage and plaintiff at the stage of trial has not been considered by the learned first appellate court.
As considered in this way, which I have read just now.
And has been considered only to the effect that
Para 21.
has been considered in the following manner. Para 21 दे देंगे. Quote कर देते हैं. The learned counsel has submitted that a reference has been made in aforesaid quoted para 21 of the judgment that any mistake in plot number is a minor discrepancy and the identity of the property is required to be seen. Right? In response, the learned counsel for the appellant has submitted that the learned first appellate court has merely referred to the judgments passed by Honorable Supreme Court, reported in AIR 1963 SC 1870, and the judgment passed by Honorable Patna High Court in AIR 2005 Patna 23, to observe that mistake in plot number is to be treated as mere discrepancy which did not must the mistake in the plot number be treated as mere discrepancy, and has further observed that in the case in hand it is also a minor discrepancy which does not affect the identity of the property sold in the year 1947. The learned counsel submits that on the face of Exhibit F, which was produced as additional evidence, and its mismatch with Exhibit 1 by A, the learned first appellate court ought to have scrutinized the materials on record
To
and
formulated point.
ought to have formulated a point
Point for determination.
for determination as to whether such mismatch has any bearing on the identity of the property. In absence of such point of determination and further such finding on this, the matter is required to be remanded back to the learned first appellate court for fresh determination on with regard to identity of the property and the impact of mismatch in Exhibit 1 by A and Exhibit F. Correct?
But only one thing, 1963 Supreme Court your lordship has said 1870, but इस पे ये this judgment is not there.
खाली reference है इसमें.
हाँ reference है lords, लेकिन I have checked in all sites, even SCC also, ये reference और citation गलत है.
पटना हाई कोर्ट सही है.
पटना हाई कोर्ट सही है. वो
और इसमें पार्टी का नाम सही है, शिव दयाल सिंह.
नोट उस पे पटना हाई कोर्ट वाला जो जजमेंट
नहीं, सुप्रीम कोर्ट वाला जज.
नहीं, सुप्रीम कोर्ट का जजमेंट नोट जो है उसका साइटेशन है नोट 62 BLJR सुप्रीम कोर्ट 273 नोट, ये पटना हाई कोर्ट का जजमेंट है, इसी में रेफर है.
पटना हाई कोर्ट का जजमेंट में 63 सुप्रीम कोर्ट
जो आपने दिया है वही.
हाँ.
इसका कौन सा पैरेट है?
63 पटना हाई कोर्ट का जो देखो उसमें रेफर है.
हाँ नोट उस पे लास्ट वाला एकदम सेम पेज में, फर्स्ट पेज में वो शिवध्यान सिंह जो है ना उसका साइटेशन है.
शिवचंद.
अच्छा अच्छा.
वो साइटेशन यहाँ गलत है.
रेफरेंस गलत है.
The learned counsel has also learned counsel for the appellant has also submitted that the citation mentioned in paragraph 21 with respect to the judgment of the Honorable Supreme Court is incorrect. the correct citation, the same judgment is also reported in 1962 BLGR within bracket
63
SC,
Supreme Court.
BLGR within bracket SC 273, and the learned counsel for the respondent has produced a
Then-
copy of the said judgment of the Honorable Supreme Court, which is
That
reported
is not
in
AIR 1963 Supreme Court 1879. वो equivalent है, ये तो है।
has submitted
पटना हाई
that
कोर्ट का judgment
वो
है।
ठीक है सर।
AIR
1963 Supreme Court 1879.
1963 Supreme Court 18
1879. पेज नंबर गलत
पेज नंबर गलत है सर।
1879.
1879, ठीक है,
70 हो गया। Actually 1879.
ये होगा 1879.
No.
सबमिशन में आ रहा है, ऑर्डर में आ रहा है सर। सही आना चाहिए।
सही आना चाहिए
सही
ना,
आना।
नहीं तो फिर वो कोर्ट भी कंफ्यूज हो जाएगा कि कौन सा जजमेंट खोज के निकाला।
क्योंकि आई चेक टू नोट इन ऑल साइड। इसके बाद
62 BLGR equivalent to 63 Supreme Court.
हाँ। नोट वन सबमिशन नोट जो एग्जिबिट ई पे जो हम आई हैव सबमिटेड दे वर अवेयर ऑफ दिस फैक्ट कि वो एंट्री में
The learned counsel for the appellant has also submitted that as per Exhibit E, the plaintiff was aware of the fact that there is some discrepancy in his Exhibit 1 by A, but the suit was filed by referring to plot number 121 and not plot number
खाता
number 121,
and not
and
खाता
no pleading was made in connection with khata number 122.
My submission note that is a tanaja having no bearing with it.
To which the counsel for the respondent has submitted that
Inadmissible
Exhibit E
in
was only not final proceedings, and the learned courts have
And it is not the admission of the plaintiff.
not laid any reliance of such on such document, and on the basis of such document, no admission can be imputed on the
In
part of the plaintiff.
In part.
ठीक है?
Yes.
After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that admittedly the registered document, the original patta was produced by the plaintiff as Exhibit 1 by A, which was the sheet anchor of the claim of the plaintiff, and so far as the defendant is concerned, its certified copy was produced before the first appellate court as additional evidence, which was marked Exhibit F. The only reason for admitting the said document as additional evidence at the appellate stage was that it indicated mismatch in connection with the description of the property so far as the khata number is concerned. The learned first appellate court, having admitted the said document as additional evidence, did not frame any issue as to whether such document, the certified copy or the alleged mismatch between Exhibit 1 by A and Exhibit F has any bearing in the matter, particularly in connection with the identity of the property between the parties. The learned first appellate court has by passing the judgment has taken care of the fact that there is a mismatch, but while recording the finding in para 21 has simply stated that the case which is in hand, it is also a minor discrepancy which not affect the identity of the identity of property sold in the year 1947. This court finds that this court is of the considered view that the learned first appellate court not only ought to have framed an issue to this effect, point of determination to this effect, but ought to have recorded a finding after appreciating the materials on record as to whether the as to whether there was any discrepancy in identity of the property as to whether the certified copy as produced by the defendants before the first appellate court has any bearing on the identity of the property. The point of determination कहाँ फ्रेम की?
Para 9 of the appellate court. इशू को ही रिपीट करो.
But same trial court का issues have been.
उसी को quoted.
The learned first appellate court considered the same issue as framed by the learned trial court. And no issue was framed with regard to, no point of determination was framed with regard to identity of the property. In the light of the additional evidence which was placed before the first appellate. In view of the aforesaid facts and circumstances, this court is of the view that the learned first appellate court, having admitted Exhibit F as additional evidence, ought to have considered the impact of such additional evidence with respect to the claim of the respective parties. The learned first appellate court, having not framed appropriate point of determination which also required scrutiny of the materials placed on record, the matter is required to be decided afresh by the learned first appellate court. No finding है ना regarding identity of property. The learned first.
It will not affect the उतना ही
वही तो
हाँ नहीं appellate court अपना कोई finding नहीं दिया, trial court का तो finding है. The learned appellate court has further not recorded any finding in connection with the identity of property. Consequently, the impugned judgment passed by the learned first appellate court is set aside and the matter is remanded to the learned first appellate court for fresh consideration in accordance with law after framing appropriate points for determination. And pass fresh judgment within a period of fresh judgment in accordance with law. आप लोग के appearance का date देंगे? The parties to appear before the learned first appellate court by filing fresh वकालत on एक date देंगे. अपलोडिंग का डेट का एक महीना बाद करेंगे. the fresh judgment be passed by the learned. Suit कब का है? 2001.
2001, 6 of 2001.
Since the title suit is of the year 2001, the learned first appellate court shall the fresh judgment be passed as expeditiously as possible, preferably within a period of 3 months from the date of appearance of the respective of the parties. The parties to cooperate. बेटर टाइटल पे चला गया, आइडेंटिटी ऑफ प्रॉपर्टी पे नहीं।
देखिए
वो पोर्शन भी कोट करना है।
Para
पैरा
21.
20 and 21. Therefore, from the above discussions. पैरा 18, पैरा 20, पैरा 21 इसको कोट करना है। हाँ 18 और ये तो so far as genealogy etc is concerned वो तो
उसमें कोई
नहीं, पैरा 18 19 तो हुआ, केस क्या है दोनों का वो नहीं। Appellate court.
therefore
Para
from the discussions para 18
पैरा 18
para 18 appellate court there is a finding therefore from the discussions ठीक है और ये para 20 है therefore from the documents para 20 है उसके बाद para 21 है regarding identity of property बाकी पे तो कोई इंटरफेरेंस नहीं चाहिए देयर इज वन फाइंडिंग इन पैराग्राफ 16 आल्सो
उसमें डिस्प्यूट नहीं है।
इसमें कोई डिस्प्यूट नहीं है
चमन बड़ी का 4 बेटा था, उसमें तो कोई डिस्प्यूट नहीं है।
उस समय कुछ सिर्फ आइडेंटिटी ऑफ लैंड।
हाँ पैराग्राफ 16 भी कोट कर देंगे ठीक है this appeal is accordingly disposed of. ये जो आप जजमेंट दिए इसमें कौन सा पैराग्राफ था रिगार्डिंग आइडेंटिटी
स्टडी करें 63 सुप्रीम कोर्ट इज द एक्चुअल
हाँ
रेफरेंस।
वो 63 ही खोज
Better to have the Patna High Court judgment that is quoted in para 13 of the Patna High Court judgment. It has been quoted. AR 1963 Supreme Court 1879. Siv Dhyan Singh.
जैसे यहाँ फाइंडिंग ये है that the effect of this decision is that where there is no doubt as to identity and there is only misdescription that could be treated as merely written.
मेयर
I think दोनों जने वही ओरिजिनल पट्टा पे रिलाई कर रहे हैं
नहीं,
Both the
ये तो
parties.
नोट्स पट्टा पे रिलाई करे 47, हम तो हुकुमनामा पे रिलाई करे which your lordship said read translated copy 41.
अच्छा 41 का
I am relying on 41 हुकुमनामा.
लेकिन given
हाँ
from the
सेम
same
सेम ex landlord same.
ex landlord same
इस पे कोई
Otherwise, everything is said they claim from 1941 for a part of the land, and we are claiming by registered patta in 1947.
हो सकता है दोनों का आइडेंटिटी ही अलग अलग होगा
इसी
वो अलग हो जाए
अगर उनका हुकुमनामा में डिस्क्रिप्शन रहता तो दिक्कत ही नहीं था। हुकुमनामा should describe the boundary प्लॉट नंबर कैनॉट बी डिफरेंट। प्लॉट नंबर एक खाता का एक ही प्लॉट नंबर होता है, 122 में 38-47 नहीं आएगा, इसलिए क्रक्स है प्लॉट नंबर।
ये जजमेंट बहुत इम्पोर्टेंट है क्योंकि ये सब बहुत रेगुलर चीजें हैं।
दोनों जज पटना हाईकोर्ट का, और पटना हाईकोर्ट और 3-4 जजमेंट कोर्ट की इसी फंड। ठीक बोले कि पटना हाईकोर्ट का जजमेंट अपने सुप्रीम कोर्ट जो अपडेट हुआ है, रियली द लॉ हैज बीन लेड।
Yes, in many judgments we see many judgments.
ये AR 1962
अभी भी आता है, अभी भी सही होता
अभी जी
है। पुराने जितने
अभी
भी
भी।
और
judgments हैं।
उगनी देवी जो
उगनी देवी,
है पूरा केसी उगनी देवी वाला जो है एवरीवन आर्ग्यूज दैट
आज 62 से लेकर 25 हो गया, 53 इयर्स पार हो गया, 63
कहाँ था?
63
40 और इधर हाँ
और प्रिवी
63
काउंसिल में भी बहुत सारे
आज भी।
मैटर्स पटना से गए।
उगनी देवी का जजमेंट आज भी रेफर होता है, अब डाइल्यूट नहीं हुआ है। वो केस चल ही रहा है।
रेफरेंस दिल्ली रेंट लॉ एक्ट जो डेलीगेटेड लेजिस्लेशन का मेन जजमेंट है। दिस इज इन दैट केस वन ऑफ द आर्गुइंग काउंसिल वाज मिस्टर बीसी। उन्होंने ही मेरा एनरोलमेंट कराया था, जब एनरोलमेंट कराया था उसी दिन बोले थे that I was one of the arguing counsel in that case. We have seen them.
Yes.
आपने भी देखा होगा उनको, आप भी थे बोले। SC घोष and BC घोष। SC घोष was primarily from civil side.
मेरा जब जैसे क्लार्क हम यहाँ काम कर रहे थे, बीसी घोष बोले हम चेयरमैन हैं, तुमको अपना सिर्फ काला कोट नहीं लाना, सिर्फ अपना फुल पैंट पहन के आना, शर्ट पहन के आना, वो हमारा तुम्हारा साइज में नहीं आएगा। उनके घर में ही उतर, मेरे घर में आना, उनके यहाँ साथ खाना खाए, फिर ले गए हमको और कराया, लाइसेंस दिए, वो तो चेयरमैन थे उस समय तो देने के बाद हमको जस्टिस प्रभाशंकर मिश्रा वाज सीनियर लॉ, वो मिल गए, ये इनको सही करा, ये पहला ज्वाइन करा। संजोग से MS छावड़ा रिप्रेजेंटिंग दी गुरुद्वारा, वही केस चल रहा था, तो छावड़ा साहब एक मुकदमा एक्सिक्यूट किए और उसमें हम वकील के रूप में सही।
These are all first वकालतनामा कोई और
पहला
नहीं होता।
फर्स्ट वकालत, और रांची में PS दयाल साहब उनको सही था फर्स्ट। ये सब लाइफ में याद है। अब राइट
But tomorrow I will pass on that judgment of verbatim जो copy paste वाला है।
हाँ।
I have that judgment.
अब ये बाहर से काउंसिल आए हैं, फर्स्ट अपील में।
From supplementary list for final dispute item 1, first appeal 77 of 2023. Item 2 and 3.
आप बहस करेंगे इस मॉर्निंग? आपकी वाइफ तबीयत ठीक है?
ठीक है, मुझे पास टेबल हमको लेके बाहर जाना है।
चलिए।
For yesterday I have taken her to doctor. Kindly.
हम लोग कौन से रिकॉर्ड से बहस कर रहे थे? फर्स्ट अपील 44।
44।
क्या बोलना है आपको बताइए।
वो डिपोजिशन की यूज कर रहे थे। The main ground is that there are sure thing is more connected in both the first two cases, 44 and
नहीं, आप सिर्फ 44 का बहस करें।
हाँ 44 में उसमें भी वही चीज़ है। Rameshwar Singh, the defendant number 3, is no way connected either with the Algoram or with the judicial law. और इनका उनके फादर का नाम राधा कृष्ण सिंह है और उनका दादा ग्रैंडफादर का नाम रामदेव सिंह है और दैट इज ऑन
Just
रिकॉर्ड।
moment, Algoram और क्या नाम है, जोगेश्वर।
जोगेश्वर
डिफेंडेंट नंबर 3 के फादर का नाम क्या है?
उनका फादर का नाम है राधा कृष्ण
राधा कृष्ण
सिंह और राधा कृष्ण सिंह के फादर का नाम है राम वृक्ष सिंह।
इनके फादर का नाम है राम
वृक्ष
सिंह और राम वृक्ष सिंह के फादर का नाम है?
राम वृक्ष सिंह का
नहीं।
उनका
राम वृक्ष सिंह का जोगेश्वर से कोई लेना देना नहीं।
नहीं।
राम वृक्ष सिंह का अरबू से कोई लेना।
कोई
आप हमको ये बताइए डिपेंडेंट नंबर 3 के फादर राधा कृष्ण सिंह है और रामवृक्ष सिंह है, इसके लिए आपका क्या क्या एविडेंस?
एग्जिबिट 9 में है।
प्लेस करिए एग्जिबिट
इनके
9
एविडेंस में भी आया है और एग्जिबिट 9 दोनों
आप
में।
दिखाइए आप एग्जिबिट 9
Exhibit 9 is the sale date which is not connected with this case, but where the names of the parties are there. It is connected with Ramkeshwar Singh name is there, and Radhakrishna is also there in that case.
Kindly allow just 2-3 minutes break. Okay.
Exhibit 9, right?
Exhibit 9.
Let me just come please.
It is the same day executed by Ramkeshwar Singh, the uncle of Rameshwar Singh. He is defendant.
Just a moment. CD executed by Ramkeshwar Singh.
Ramkeshwar Singh, who is the uncle of defendant number 3.
Uncle of defendant number 3 and therefore brother of Ramkrishna.
Radhakrishna Singh.
Brother of
Radhakrishna.
brother of Radha Krishna Singh. Okay.
Kindly turn the last page of the sale deed. This is the record of Rajasthan Bhumi Sudhar Vibhag, Bihar Sarkar.
Yes.
My lord, column first, serial number 3 Radhakrishna Singh, पिता का नाम रामवृक्ष सिंह. Column first, item number 3.
Ramkeshwar Singh लिखा हुआ है.
Radhakrishna Singh is the father of defendant number 3 और इनका नाम आया है
Last page में ना.
लास्ट पेज पे. रामकेश्वर सिंह का तो सिग्नेचर है, अरुण कुमार का सिग्नेचर, बिकॉज दे आर द सेलर ऑफ
हाँ. तो
फर्स्ट कॉलम में आइटम 3 राधाकृष्ण सिंह, पिता और पति का नाम रामवृक्ष सिंह.
ये डॉक्यूमेंट कौन से हैं? I can't read this document. थोड़ा सा अपना आपके पास डॉक्यूमेंट उसको मार्क किए
पर सभी कॉलम फर्स्ट में 3rd नंबर पे है.
रामकृष्ण सिंह पिता
रामकेश्वर सिंह के पहले राधाकृष्ण सिंह, ऊपर
राधा कृष्ण सिंह
पिता रामवृक्ष सिंह.
रामकेश्वर सिंह, राधा कृष्ण सिंह, पिता का नाम कहाँ लिखा है?
नीचे लिखा है, लाइन में मार्क कर दीजिए। मार्क कर दीजिए।
This is voter I card, क्या है?
No, ये this is the part of the sale deed, that is record of राजस्व भूमि सुधार विभाग बिहार सरकार. It has been given there for the genuinity of the person.
ये राजस्व विभाग कैसे किसी का बाप के नाम को सर्टिफाई करेगा?
जी,
ये कैसे
वो
सर्टिफाई?
खतियान का पार्ट है, खतियान से आया है.
This is a part of the sale deed.
This part of the sale deed. Yes. There are three: Ramjanan Singh, Radhakrishnan Singh, and Ramkeshwar Singh. Three brothers, and their father's name is Ramrich Singh.
ऊपर पहला है रामचरण सिंह,
Ramjanan Singh.
रामजनन सिंह, दूसरा क्या है?
दूसरा राधाकृष्ण सिंह.
राधा कृष्ण सिंह, और तीसरा है राजकेश्वर सिंह,
रामकेश्वर.
रामकेश्वर. ये बिल्कुल भी नहीं बता रहा है. ठीक.
So my submission is that Rameshwar Singh, who has executed power of attorney,
All sons of
Ramrich Singh,
Ramkrishna.
and the defendant number 3 is the son of Radhakrishna Singh.
आप उनको ये बताइए कि ये डिफेंडेंट नंबर 3 सन ऑफ राधा कृष्ण सिंह,
Yes.
ये तो राधा कृष्ण सिंह के बाप का नाम आ गया, ठीक है?
हाँ.
डिफेंडेंट नंबर 3 इज सन ऑफ राधा कृष्ण सिंह. डिस्क्रिप्शन में भी वही है,
सब जगह वही है.
प्लेट में
Plaint में भी वही. Yes.
वही. So there is no dispute that he is
There
son
is
of
no
Radha
dispute.
Krishna Singh.
There is no
Dispute is whether Radha Krishna Singh was son of Ramrich Singh or not.
Correct. No. Yes. They are
Right, na?
disputing it. Yes.
There is no dispute that defendant number 3 was son of Radha Krishna Singh.
Yes. No.
Is there any dispute on this? Okay.
So as such, the defendant number 3 has no right to execute any power of attorney with regard to the land in question. So as such, the power of attorney is not a valid document, and on that basis a sale was made. On that sale, another sale was made. So it is that sale is void ab initio. This is my prayer to declare this sale as void ab initio. from very beginning it is not valid.
So merely because the 2010 you have not challenged is not fatal to your case.
Yes.
Neither 2010 is under challenge, nor power of attorney is under challenge.
No, that too, that's one sale and one power of attorney, other power of attorney. Though I am not
Power
challenged.
of attorney is also a registered document. Power of attorney is also a registered power of attorney. So neither you have challenged the power of attorney, nor you have challenged the sale arising out of power of attorney,
Yes.
but you have challenged the subsequent sale of the year
Subsequent sale.
2011.
So, yes, that's
So that is
that's
not
true.
fatal because the identity of the person is absolutely proved to be incorrect. And he is
Incorrect.
totally
Yes.
unconnected to the family.
Yes, that is my case. And whereas the plaintiffs, admittedly they are nephew of Jogeshwar. Admittedly they are nephew. There is no dispute on that. They are nephew of Jogeshwar Ram. Jogeshwar Ram and Algu Ram self-acquired the land. It has come in the evidence also that it is self-acquired land. Jogeshwar Ram on the basis, Algu Ram on the basis of Panchnama, given all his property to Jogeshwar Ram. There is no partition in that very
That's
land. More so
They are claiming to be the descendant of the recorded tenant,
Yeah.
and they say that the co-tenant died issueless.
Co-tenant died issueless. Both the tenants died issueless. Not only co-tenant, both the tenants died issueless. And the three plaintiffs are son of Taraknath, who is full brother of Jogeshwar. They are admittedly their own nephew of Jogeshwar. So that is my case. Therefore, the whole case is based on on the basis of the power of
And
attorney.
you are claiming the title on the basis of?
I am not claiming that based on the basis of title. I am claiming on the basis that Tarak, on the basis of Panchnama. Through Panchnama, Algu Ram has given his property to Jogeshwar Ram. It was not partitioned, and Jogeshwar Ram executed a power of attorney before his death in favor of the plaintiff number 1, Krishna. और साथ में लोग रहते भी थे. They were living with Jogeshwar Ram since 84. There is no dispute. They are living with them. They are caring Jogeshwar Ram, and Jogeshwar Ram treated them as his son, though they are not. But that is admitted question that Rameshwar Singh is outside. And nephew. We all the three are nephew.
You are the nephew of
Jogeshwar. Admitted question.
And they are claiming through that power of attorney and sale deed.
Yes.
Is there any property you are also claiming through any power of attorney?
No. These property were given, all of attorney given by Jogeshwar Ram.
That is a separate.
That is
Power of attorney for the whole property.
for the whole property.
Including the property of Algu Ram.
Yes.
Because Algu Ram had orally transferred the property.
और एक पंचनामा उन्होंने लिखा था.
उसमें वो सिग्नेटरी है पंचनामा?
थंब इम्प्रेशन है वो, that is not clear there.
नहीं है. नहीं है.
So that is not
थंब
an-
इम्प्रेशन भी नहीं.
Maybe there, but that is admitted question that we are making.
और इनको तो सिर्फ अर्गू राम वाले पोर्शन से मतलब है. योगेश्वर राम वाले पोर्शन से तो इनको मतलब नहीं है.
इनको दोनों से मतलब है. पहला 2 केस में अलगू राम और थर्ड केस में जोगेश्वर राम.
अच्छा. पहला 2 केस में अर्गू राम से रिलेटेड.
हाँ.
तो अर्गू राम और जोगेश्वर राम का जब पार्टीशन हुआ ही नहीं
था. लेकिन
तो
ये
फिर आप
हाफ, ये उसको हाफ मानने के 2.55 अलगू राम का है और 2.55.
तो अर्मा की नहीं हुआ तो कैसे पता चलेगा जो पावर ऑफ अटॉर्नी ने बेचा है वो अर्गू राम वाला बेचा है कि जोगेश्वर राम वाला बेचा है?
वो बस एक थोरली सबमिशन करके बेचा है कि ये अलगुराम का है। डिमार्केशन नहीं है उसमें, डिमार्केशन के लिए तो नोटिस आया था मेरे पास में, व्हेन आई केम टू नो अबाउट द केस, अबाउट द सेल।
तो ये तीन केस है, तीनों में जो प्रॉपर्टी इन्होंने क्लेम किया है वो पावर ऑफ अटॉर्नी ने एग्जीक्यूट किया है
जी,
और उसी के बेसिस पर इनको सेल डीड हुआ है और वो क्लेम
यस दैट
इन ऑल द थ्री
इन ऑल द थ्री।
अच्छा, एविडेंसेस आर आल्सो द सेम इन ऑल द थ्री केसेस की फर्क है? प्लेन रिटन स्टेटमेंट में
because in third case power of attorney has been executed by Baijnath Singh. Baijnath Singh is brother of Jogeshwar. Okay, that is different. In first two cases, Rameshwar Singh ne
why Baijnath Singh has executed the power of attorney
for claiming 1/3 share of the property of Jogeshwar.
why 1/3?
Because Jogeshwar Ram had no issue. Jogeshwar Ram had 4 brothers. Jogeshwar Ram dad issueless, 3 brothers remains. One is the father of the plaintiff, and out of the rest 2, Baijnath is one. So he is saying that the court is saying that since there is no power of attorney disputed, though no panchanama is there with respect to Jogeshwar Ram's property, no partition in the property of Jogeshwar Ram. Therefore, the brothers would be the second claimant of the land. Their wives are also not alike. So, brother is the second claimant of the land of Jogeshwar Ram. So, out of 2.55 acre, 85 decimal was given through power of attorney by Balmiki Singh.
By this
Baijnath Singh.
Baijnath.
One out of 2.55 share of Jogeshwar Ram, 85 decimal has been executed by Baijnath Singh in favor of उसमें डिफेंडेंट नंबर 2 वाला दिलीप सिंह लाला विवेक प्रसाद।
Apart from Exhibit 9,
Yes.
which document do you have to show or which evidence do you have to show to substantiate your case that Radha Krishna Singh had or defendant number 3 had nothing to do with it? ये तो आपने exhibit दिखाया, ठीक है? इसके अलावा क्या
एविडेंस में भी आया है,
oral evidence में आया है?
हाँ आया है oral evidence
हाँ,
में।
किसका oral evidence आप अप्लाई करते हैं?
डिपेंडेंट का भी दिखाए थे।
पहले आप अपना प्लेंटिफ का दिखाइए।
हाँ, प्लेंटिफ का दिखा रहे हैं।
डॉक्यूमेंट्री एविडेंस में एक ही ये एविडेंस है दैट दिस शुड बी सफिशिएंट, क्लिंचिंग नहीं है अकॉर्डिंग टू यू?
है उसमें एविडेंस वाया सब में आया है।
आप हमको बताइए भाई, आप कौन सा एविडेंस पे आप रिलाई कर रहे हैं टू कम टू दिस फाइंडिंग दैट डिफेंडेंट नंबर 3 हैड नथिंग टू डू विद द फैमिली? एग्जिबिट 9 हमको दिख गया, इसके अलावा क्या है? प्लेस करना पड़ेगा ना, फर्स्ट अपील है। इसके अलावा पहले डॉक्यूमेंट खत्म कर लेते हैं, फिर आपका होगा।
तो प्लेंटिफ का हम एविडेंस प्रोड्यूस कर रहे हैं।
डिफेंडेंट डॉक्यूमेंट सब खत्म हो गए, डॉक्यूमेंट और कोई डॉक्यूमेंट नहीं है?
नहीं, ओरल एविडेंस अभी तक नहीं हुआ कभी।
भाई ओरल जैसे आपने एग्जिबिट 9 पे रिलाई किया, और कोई एग्जिबिट पे रिलाई कर रहे हैं इसके लिए?
एग्जिबिट तो हाँ, वो फैमिली लिस्ट चल रहा है, वो एग्जिबिट है
एग्जिबिट 7
एग्जिबिट है 7, that is genealogy issued by the Anchal Adhikari, because they are native of Bihar, so genealogy has been issued from Bihar. They came over here in Jharkhand. Now their entire genealogy remained in Bihar, so it has been issued in Bihar.
इसमें क्या रिलाई कर रहे हैं?
ये अलगू राम का इसमें जेनोलॉजी है, इनका कोई आगे में नहीं, भाई है इनका भाई का भी जियोलॉजी है जिसमें कहीं भी रामेश्वर राम का नाम नहीं आ रहा है या राधा कृष्ण सिंह का नाम नहीं आ रहा है या फिर उनके पिता रामवृक्ष सिंह का नाम नहीं आ रहा है। स्वर्गीय देवनाथ सिंह झगड़ू सिंह एंड अलगू सिंह। झगड़ू सिंह फर्दर had 2 sons, Ramashray Singh and Bihari Singh. Ramashray Singh has 1 here, Sunil Kumar. Bihari Singh has 3 sons, Jitendra Kumar, Satyendra Kumar and Jogendra Kumar.
तो इसमें ना तो रामकेश्वर सिंह का नाम है
नहीं, ना तो रामवृक्ष सिंह से आगे भी किसी का नाम नहीं। रामवृक्ष सिंह का भी नहीं है, राधा कृष्ण सिंह का भी नहीं है और रामेश्वर सिंह का भी नहीं है।
इनके दादा का नाम नहीं है। डिफेंडेंट नंबर 3 के दादा का नाम नहीं है।
उनका भी नाम नहीं है।
उनके दादा क्या नाम था?
रामवृक्ष सिंह।
रामवृक्ष, उनका भी नाम नहीं है।
इनका भी नाम
और रामवृक्ष के पिताजी का भी नाम नहीं है। कुछ नहीं पता चला,
नहीं।
उनका पता ही नहीं।
वो तो है ही नहीं, वो तो रामवृक्ष सिंह ही नहीं है। रामवृक्ष सिंह से के बाद का ही है, रघुराम तो उनके बाद का ही है।
ठीक है,
उनको ऊपर बढ़ता रहते थे।
ये हो गया एग्जिबिट 7। इसके अलावा क्या बोलते हैं?
ये
इसके
दो
अलावा
डॉक्यूमेंट
क्या
है जो शो करता है रामेश्वर सिंह ये कहीं नहीं।
और बताइए, और कोई डॉक्यूमेंट आप रिलाई करना चाहते हैं?
रामेश्वर सिंह के लिए दो डॉक्यूमेंट है मेरे पास में जो खातपालन को नहीं है अभी से भी।
और ओरल एविडेंस किसका रिलाई करना चाहते
हैं? सुदामा सिंह जो है इसमें ठीक है, उनका और पहले प्लेंटिफ नंबर 1 का पहले पढ़ना है कृष्णा सिंह जी का।
कृष्णा सिंह,
नहीं सॉरी, सुदामा सिंह हाँ ये प्लेंटिफ नंबर 2 है।
किसका एविडेंस पढ़ना चाह रहे हैं?
सुदामा सिंह ये प्लेंटिफ नंबर 2 है लेकिन इनका प्लेंटिफ विटनेस नंबर 1 है।
PW1 प्लेंटिफ नंबर 2 और सुदामा सिंह,
यस।
इनके बेटे हैं
ये तारक नाथ जी के लड़के हैं, जोगेश्वर राम के वो नेफ्यू।
कौन सा पैरा पढ़ना चाहते हैं? पैरा बताइए।
पहले पारा 3 देखते हैं, इसमें आया है कि स्वर्गित कमाई है, इसलिए इसको दिखा रहे हैं। यह कि
पैरा 7, एक व्यक्ति रामेश्वर
पारा 3 से इसको दिखाई देंगे।
Post lunch देखेंगे. Post lunch.
Grateful. I was needing a video.